Ready? Yeah. Oh, I'm sorry, he phoned yesterday to say he can't make it today. Marshall also can't make it. I think he copied you. I think so should we take roll?
Okay.
Okay.
Amy Bomsey? Stephen Bundy?
Yep.
Kendra Basner? David Carr?
Here.
Eric Deitz? Andrew Dilworth? Wasn't he just here?
Nope,
Oh, okay.
he's not making
Justin
it.
Fields?
Here.
Matt Hodell? Toby Inlander? Adam Koss?
Here.
Amber Lee? Dina Roche? Teresa Schmid? Richard Solomon?
Here.
Steven Sparta? Marshall Whitney?
Is anyone from the public who wants to be heard? Okay. So, staff report.
Okay. Just also a friendly reminder, as I'm reminding myself, please use your microphone when you speak today so that all our comments can be captured on the webcast.
Actually, I want to just say one quick thing to Andrew.
Please.
Are you going to get into the whole 7-member thing? Can you skip that and come back to later? Because I just want to, well, it just, you got it, okay. Okay, all right. Go, sorry.
Okay, no problem. So the two opinions that you approved for publication last meeting are going to be prepared to go to the board on their March 8th meeting for publication. So we'll have a report following that when they're finally approved. 14-0004, witness perjury is currently out for public comment. The deadline is March 27th, and we've received a handful of comments on those, and I've been forwarding those to the drafting team as we've been getting them so they can consider those. The task force on the access through Innovation Legal Services, I believe that's the full name, met in December and has their next meeting a week from today in Los Angeles. And they are considering questions on revisions to the rules of professional conduct, studying multidisciplinary practice and the unauthorized, what constitutes the unauthorized practice of law, and considering whether recommendations can be made to amending those policies to allow for greater access to the legal system. Those meetings are also webcast, and so the next meeting begins at 10:30 a week from today. If you care to follow it at your desk, we encourage you to do so. Their recommendations, whatever their recommendations may be, they'll go out for public comment. And if they stick to the schedule that they currently have set out for themselves, I believe the public comment would begin in June or July. And of course, staff, myself and Mimi, will make sure this committee is aware of whatever recommendations they're making so that we can provide input, depending on what form those recommendations go out in. And then transitioning to something that will affect this committee and
Andrew, there's a question.
yes,
Can you repeat the name of that committee again, the
it's
official
called
name?
the Task Force. Oh no, it's the Access Through Innovation in Legal Services Task Force.
Okay.
Through innovation.
of Legal Services.
Does it have a nifty acronym?
And who's on that?
ADLS, it does.
Or Eagles.
ADLS.
And who's on that committee? Like how many people? It's attorneys, right?
It's a majority, non-lawyer majority.
No,
And
could be trouble.
I don't know the total number, we had 24, 21. There is a roster, we could get a roster for you. There's an FAQ on the State Bar's website as well about what they're studying. I can certainly share that with anyone who's interested. Just let me know at a break and I'll email it to you for sure.
Thank you.
Sure. Okay, so taking a step back, 2 or 3 years ago, the State Bar, through legislative mandate, is required to go through a governance and public interest task force to evaluate what the State Bar is doing and how it's doing it. In conjunction with the State Bar transitioning from an associational bar to a regulatory bar, as part of that process, they looked at all their committees and commissions. I think we were tangentially aware of this because COPRAC is a standing committee of the bar, and at that time, many wondered what might happen with COPRAC. Early on, COPRAC was determined to be primarily a regulatory function within the bar, and as my boss Randy describes it, we were given a clean bill of health, and we were deemed to stay with the bar. And so much of the time has been spent on other committees and commissions since that initial recommendation that COPRAC stay with the bar, examining what their function is, what they are doing, is it primarily a regulatory function or not? And that's been going on for the better part of 2 years as of now. And there's a group of committees and commissions that did not have an easy determination of yes or no, they should stay or they should be sunsetted, and that was known as the Appendix I review. The Governance and Public Interest Task Force had a big report. Part of the report was an Appendix I section, and that's where these committees and commissions found themselves, so they're known as the Appendix I review. The bar is concluding their review of Appendix I, and I think their final recommendations are going to be made at the board meeting here in January, 2 weeks from today. Regarding those committees. And as part of their wrapping up their review of the outstanding committees and commissions, the board has also made global recommendations for all committees and commissions which are going to stay with the bar. So these global recommendations will affect us as a committee that's staying with the bar. And those recommendations include that all committees and commissions have a default size of 7 persons unless a recommendation can be made for smaller or larger number of persons. And another global recommendation is committees and commissions will no longer have a special advisor. Committees and commissions will no longer have a nomination subcommittee. I think the nominations will probably be reviewed by staff. That's still being determined as to how that process will occur. And so by transitioning to a 7-person committee, if that's the ultimate recommendation that the board makes for this committee, that'll be achieved through, I'm assuming it's most likely that'll be achieved through attrition. And what that means is if you've been appointed this year for the first year to a 3-year term, have no fear, you will be able to serve out your 3-year term. But as each appointment cycle comes to an end, we're going to most likely be reducing the size of people we add to the committee until we achieve the size that the board deems appropriate for this committee. And that's that. Does anyone have any questions? Yes.
Is there any recommendation that it remain its current configuration and
Current numbers, or is that something still being debated, or is it something that they're going to, I mean, is someone making that argument, I guess, that this committee should be different from what's going to be generally recommended?
So that no specific recommendation has been made that I'm aware of for this committee yet. However, for all committees, including this committee, the default size is 7. A few committees and commissions have been deemed to be able to exist at 10. There are none that I'm aware that's larger than 10. There's one I'm aware that was recommended and approved by the board to be 5. So that's the scale that I'm aware of as of today.
Wait, Andrew, can I just understand something about process? So some committees, the board has already made a determination about size,
Correct,
but others not.
correct,
And COPRAC, the answer is not yet.
correct.
Okay.
Are we going to be asked for any input on that size?
I don't know. I would think so, but I don't know.
Would our input be welcome?
Absolutely.
I have a question that's related. And is my understanding, you shared some materials with leadership, which was very helpful. My understanding is that the criteria for going up or down, right, from 7 is workload and representation, right?
Those have been two of the
Those
aspects that
are
have
the
been.
two that have been identified.
Correct.
Right, so if we're thinking of making a submission, we should make it on that basis.
Yes, I'd recommend that.
And there's a mention in the materials you sent us that there is a recommendation coming for COPRAC.
Correct.
There's no recommendation for COPRAC in the materials you sent us.
Correct.
But there is a recommendation coming that's supposed to go into, I don't know what, the part 4 of the board book, I don't know what that is.
Right. So the board book is a document that governs the operation of the board, for lack of a better description. And currently, COPRAC's rules and operations are contained in the board book. And all committees and commissions' rules and operations are going to be reviewed and revised. And that will happen for this committee as well.
Is there a timeline for when that recommendation is being made?
So I don't know the exact meeting at which it's going to be made.
And who's going to be making the recommendation?
Staff of the State Bar will be making a recommendation to the board.
About COPRAC?
Correct.
And when you say staff, is it your office?
It's probably the executive staff.
Sorry, does that mean your office? I'm just not clear. Who executive staff?
So I am not an executive staff. There's Leah Wilson, the executive director, is executive staff. Donna Hershkowitz, the chief of program, who oversees the Office of Professional Competence,
Got it.
Will you
constitutes
guys
executive
will
staff.
you and Randy will the Office of Professional Competence be asked for a view?
I would hope so, but I don't know. And certainly if we are, I'm
Do you think-
prepared and
do you
will
think-
advocate for it.
Would it be possible to, I suppose we can do this independently, but would it be possible to find out what the timeline is?
Sure, I can
Because
ask.
that would, I think, be helpful in thinking, I don't know, we'll see what the sense of the committee is. But if the sense of the committee were that it would be desirable to make a submission on optimal size, it would be helpful to know when that is needed in order to get a fair hearing.
Correct. So the next board meeting is March 8th here in San Francisco. And there is a board meeting January 25th in Los Angeles. I have not been informed that we are coming up for the January 25th meeting. That's not to say that we aren't, but no one's told me, so it remains a possibility, I guess. Yes, David.
Yes, you probably said this, maybe I missed it. The decision as far as the staffing level is made by the board as a whole.
That's correct.
Okay.
So the board made global recommendations that apply to everybody. Also, no meetings on Saturday unless you can submit a justification for the reason why. Just general global changes for committees and commissions going forward. One of them is the default size for all committees and commissions is to be set. However, there are examples of other committees and commissions that have made a request for to go larger than 7, and those have been granted. But the default is 7. You have to make a compelling case to go larger. And staff makes the recommendation, and the board would either approve, amend, or deny. Good? Okay. And outside of that, I think those are all the announcements I have today, unless Mimi has anything else. Okay?
Oh, one thing, just if
Oh.
during lunch you guys, no, I didn't get any submissions or suggested topics for the ethics symposium. So if you guys have those, can you give it to me at lunch so that I could add it to the lists for when we talk about those topics, possible topics later on?
It's a good idea.
And the other thing which is tangential when we'll get to the symposium topics is, as we had our last meeting, we met with the Mandatory Fee Arbitration Committee. Part of this review, Appendix I review, is that, as you're aware, COPRAC will be assuming some of the responsibilities that Mandatory Fee Arbitration Committee previously conducted. And when we get to the symposium topics, we would like one of the topics to be a fees or fee arbitration topic, certainly moderated by a member of COPRAC. We can reach out to some of the folks on fee arb to participate. Doesn't have to be arbitration specific, but I think, you know, the new rule about advanced fees, there's plenty of ground to plow with respect to fees issues. But I think it would bode well for us to take on that issue as one of the panel presentations. And there's a list of those in the materials as well.
Of fee type issues?
Exactly, fee topics that might present themselves as.
So the ones that appear in that list, I received from the staff person who handles the MFA committee. And so she solicited ideas from her members and so they sent her an email and she compiled it, and that's what you guys have.
Okay. That it from staff?
That's it.
Thank you.
Hopefully that was enough.
Okay. So I
Action
was,
summary? Amy,
yeah.
can we do the action summary approval?
Oh, of course, absolutely, sorry.
Sorry,
It's good.
I need a motion.
I move that we approve the action summary for the September 7th meeting.
I second that.
December 7th. Sorry, I just have to make it correct.
I
All right, Amy,
Yes.
Stephen Bundy,
Yes.
Amy Basner,
Yes.
David Carr,
Yes.
Eric Dykes, Justin Fields,
Abstain.
Matt Hodell, Toby Enlander, Adam Koss,
Okay.
Amber Lee,
Yes.
Dina Roche,
Yes.
Teresa Schmid,
Abstain.
Richard Solomon,
Abstain.
Steven Sparta, Marshall Whitney. Thank you.
Okay, so, I sent, some, written proposed changes to, the directory and rating website that I asked Mimi to, make available, and they're over on the table. So I think I'm gonna, maybe let you guys skim through. They're not extensive, but they felt like, since we're trying to get that one out, that I felt like it might be better to have them in writing. So what I'm gonna ask, I'm gonna skip that for now and ask if maybe we'll take a few minutes before lunch, or, you know, extend the period a little bit so you guys have 10 minutes to look at those. So I don't wanna start with that. So the ones that we're, the plan was that we were gonna talk about the obligations when departing a firm, lost or stolen laptop, ancillary business, which we came close to approving last month, and then we got held up because we were missing a conclusion. So that one's still on our list. Then the advising a marijuana business, and duty of confidentiality of prospective client. Marshall's not here, but I still think it could be profitable to talk about that duty of confidentiality if we get there. But so I think we should start with the departing a firm opinion, Dina's opinion, which are, is that in our main materials? No, they came a little bit separately.
Yeah.
So Dina, take it away. Anything you want to say about the changes you made?
Yeah, just briefly, since the last meeting, I revised, the issue included a digest and a statement of facts and conclusion, and then made some changes based on comments from the committee at the meeting last week. And then I sent a draft to the subcommittee and got some feedback from Steve and made some additional revisions. I think in terms of substantive revisions, the effort was just to kind of clarify issues related to the notice requirements and then the issue related to solicitation and kind of separate that. Hopefully make that more clear in terms of what we're talking about with respect to the requirements for notice and then when it's permissible to solicit and how that ties into that. So those were the changes. I don't have any comments about those changes, but welcome additional comments from anyone related to the changes.
Let's see, Justin or Amber, since you're on the subcommittee, did you want to offer any comments?
Sure. We did this a few days ago, so might take a second here, but in the digest, I think, and this is sort of a global minor tweak, rather than saying, when a lawyer wants to leave a firm, I think we should just focus on the fact that the lawyer's departing the firm rather than get into the motives. They want to, they decide to, they're forced out. Let's just take that out entirely and just say the guiding ethical principles that govern a lawyer's departure. And there's a couple other places where we talk about the lawyer wanting to leave or all that. I think we can just keep it as the lawyer's departing. Similarly in the digest, the phrase shows up a couple places, each lawyer. I think we're talking about the lawyer and the law firm there, so I think we might want to clarify that because each lawyer, we could be a little more precise there. So same thing in the statement of facts, we start off a lawyer wants to leave. Again, I think we should just change that to a lawyer's departing or something along those lines. In terms of the discussion section, this is very minor. We say sort of the last line of the sort of preface to the discussion, while the opinion will not seek to resolve issues of substantive law, it may identify. I think we can just say that it will identify, because it does. And then similarly in that sentence, we say we may identify some legal issues, and then we reference ethical issues. So it wasn't clear to me if the legal issues and the ethical issues were one and the same. So I think we should just clarify exactly what we mean there. I'm not exactly sure what we were getting at, but
I'm sorry, can you indicate where you're?
It's right here. Legal issues versus ethical issues.
Okay.
right. So if we mean the different things, I think we can just play with that language. If we mean the same thing, we should just change it so that it's consistent.
Should it be legal?
Yeah.
And many of these ethical issues, I think, is that
Yeah,
what you're
no,
getting at,
that's-
Justin?
I don't know if we mean different things, and if so, what?
It's different.
So that's, basically that sentence needs to be cleaned up.
Yeah.
Right.
Just keep out the legal.
Yeah, or just say
Identify
issues.
some issues. Yeah.
Yeah, just say.
The point is to say that there are additional issues besides ethical issues that we're gonna potentially identify some of those, but
Yeah,
Yeah.
exactly. Just
so it just
say
needs
that.
to be cleaned up.
Yeah, just minor cleanup. In terms of, and I know we're changing the line numbers here a little bit, but page 3 of the red line, around line 111, 112, there's an added sentence about a lawyer must withdraw from the representation. For me, the way I saw that sentence, it just sort of, we didn't need it. We already sort of make a good explanation in that paragraph about a client's right to choose counsel, and just seemed like we were moving into a direction that we don't necessarily need to. I don't feel strongly about it, but I just offer that as maybe an example of a sentence if we're looking to cut things and make the opinion a little bit shorter. I'm not sure that we need to raise that issue, but again, I don't feel strongly about it. Similarly, in the red line, page 3, line 124, the sentence at the bottom of page 3 starts.
Just could you slow it down just for a second? I'm sorry, where are you now?
Sure, page 3 of the red line, line 124, the
Okay.
bottom,
Okay.
starts this property notion.
Mm-hmm.
From there through page 4, line 128, the sentence that ends, "This is understandable." I would propose that we just cut that.
So you know, Gina, I'm not actually deleting anything, I'm just gonna make notes and highlight the sections, okay.
Thank you.
Page 5 of the red line. And again, this is just wordsmithing. I think we can shorten the discussion there just to highlight that it's the client's the client's interest that needs to prevail over any tension or conflict between the departing lawyer and the law firm. So I think, for instance, we could just say,
What line are you on?
page 5, top of page 5, around line 166. So where there's a conflict between the departing lawyers and the law firm's ethical obligations to clients and the lawyer and firm's obligations to each other, I think what we're trying to say is that the former should prevail. So maybe that's just under that sentence. Lawyer and firm's obligations to each other, or something like that. Again, just to shorten it.
Yeah, I think that was a suggestion, that language that Steve made, although I'm not sure, I don't know if it was there before.
That would be consistent with the tone of the rest of the opinion. It's must prevail.
I have no idea where you're at.
So we'll move on to page 8 of the red line. Look, I understand this is one of those that we're just sort of flagging, but I'm wondering in the paragraph that starts at the top, this is an area where. We then have a discussion about notification by the departing lawyer to the client that she's leaving. Prior to that time that she provides notice to the former firm may be construed as a breach of the departing lawyer's fiduciary duties or contractual obligations. I'm wondering if we need a because sentence there. I just felt, like as maybe a reader not as familiar with this area might be trying to understand why that is. We touch on it in other places, but I'm thinking we might want to consider just a very short because type of statement to explain further there. Page 8, line 304. I'm wondering if instead of advance notice to the client, we want to say prompt notice or something along those lines. I'm not sure exactly how advance notice might be interpreted. I'm not sure if prompt is the right word, but I don't think advance is either. Handwriting there, so I'll ignore that. page 11 of the red line, line 429. We say, however, it has been suggested. Again, I know we're speaking in generalities there. I don't know if there's someone or some reference citation that we want to either footnote or explain there.
There's a citation at the end of
Oh,
that.
is
If you
there?
turn the page. I'm not,
Oh, you're right. Yeah, I just missed that. I'm sorry. Then ignore what I just said. So then in page 12, line 451, any departing lawyer who will be taking a current client. So, the opinion talks about how the property notion of, it's your client versus the firm's client. That's not true at all. The client's one with all the rights and they get to choose who their lawyer is. I think that we're kind of, the way that we phrase that, we're kind of undercutting our own point. So I think that we should remove sort of the property notion there, that the lawyer's taking the current client, and just massage that to say something like, when a current client may be transitioning to the new firm with the departing lawyer, the lawyer must ensure that she's competent to handle, or something like that. That's it. Those are my specific comments. I think that this opinion is in really good shape. It's going to be very helpful to, I think, most practitioners don't have a good handle on these issues. And then to the extent that we're able to, continue to shorten the opinion a little bit, I think the substance is all there. It's just a matter of getting it into final shape. So I think, as people have said repeatedly, Dean has done a great job with this opinion. I think this is really going to be a fantastic help to practitioners.
Well, I already told Dina that I thought she did a great job with the revision and addressed a lot of the minor quibbles that I had from the prior draft. I actually, Justin, what was the first comment that you made about how we should change, instead of saying a lawyer wants to leave?
Yeah.
I actually kind of like that it says wants to leave, because it makes the lawyer think about the ethical obligations as he or she is thinking about a possible departure. And we're not saying that, we're not putting a clear black and white time limit on when the lawyer should start thinking about these things, but I don't think it's a bad thing to sort of implicitly, suggest to practitioners, like, you should always think about your obligations to the clients and put the client's interests ahead of whatever motivation might be going on in your head in thinking about departing the firm. So I like that part. I don't know how.
can I make a comment about that? I think, my view is that I think that the change that Justin's suggesting in the digest makes sense in terms of just starting it saying the guiding ethical principles that govern the lawyer's departure, and having that changed. But I think in the statement of facts, it's fine to say that a lawyer wants to leave a firm, because that's the facts of this case. In this particular statement of facts, the lawyer wants to leave her firm. So that's what I would, and I don't know if it's elsewhere, if you saw that concept elsewhere, but
It was just those two. I mean, I think the facts are sufficiently massageable where, again, we can remove the motive, because it's, at least in my understanding, lawyers don't necessarily just want to leave a firm, they might need to leave the firm. And so I want to make sure that it's abundantly clear to the readers that regardless of why you need to leave your firm, whether you want to or you're asked to leave, this opinion is guidance for you. It's not just about voluntary departures, it's about any departure whatsoever. These are your ethical obligations. So that's why I was saying, let's take out the motive as to why the reason that the lawyer's departing, and just make it an opinion about lawyers departing regardless of what.
Or make that express. It says it doesn't matter what the motive is. Maybe it's better to say it.
Because it doesn't.
Capture your point.
Because it doesn't. And I think that's an important point to make to practitioners. Look, it doesn't matter that you wanted to leave, and so you think that all your clients should come with you because this is voluntary, or you're being pushed out because the law firm thinks that, these are their clients, this and that or the other. These are your obligations under all circumstances. So it makes clear that the opinion has a sort of a breadth to it.
Right.
And it's applicable under any circumstance.
That makes sense to me. On page 8, Justin, again, already may have addressed it, but the point about this is where there may be an overlap with substantive law. I wonder if we need that paragraph?
Which one?
I'm trying to find
Which line?
it.
Which
Red line, give me one sec, page 8.
298.
Thank you.
Oh, 298.
Right.
Just flag it and get all the numbers off and everything from that.
The whole paragraph, the whole.
Right.
Well, what, is there such a thing in an agreement with an associate that if the associate departs, all the business the associate is working on, quote, belongs to the firm? Associate shall not solicit, take. Is that something that's in associate agreements now and something we should think about and address?
That would be,
I'm getting
yeah,
Okay.
I'm not sure that would be.
Sometimes there's non-solicitation provisions, that would be different than notice provisions, right? But
Right.
sometimes there are, whether or not you could argue that they are, against public policy
Well,
or
this
what that
one,
looks
yeah,
like, that's a
yeah.
whole other thing that I don't want to address in this opinion. But sometimes there are in partnership agreements, those types of provisions.
Because by implication, this says those are not enforced, they don't apply. Right, this ethical obligation would trump a contrary contractual. It doesn't make sense to say that, if it's to the extent that something is in an agreement that.
Well, I mean,
inhibits
the
client.
solicitation issue is a permissive thing in this context. So I'm trying to make it clear by way of this opinion that notice and what is considered to be notice, which involves communicating a lot of information to a client about the departure and the reasons for the departure, what's going to happen as a result of the departure and what it's going to look like for them and what they want to do and why they may want to go with the attorney or not. Those are things that are implicated in the notice requirement. That's what the opinion's saying, and that's what I think the rules require. The issue related to solicitation is a separate issue that is permissible under the rules and permissible to solicit. And there's a potential that it kind of weaves into whether or not, that is in violation of rules related to competition or intentional tort interference with prospective economic advantage of the firm, those types of issues. So that is something that is a fact-specific issue to analyze in those situations, and what is notice, what is solicitation, when does the solicitation take place. And so, that's something that I want to avoid, but I also, if a person is communicating with clients well before they give notice to their firm, for example, and trying to say, hey, I'm going to go here and you should come with me, there certainly would be arguments that the firm would have that is that's actionable conduct that breaches a fiduciary duty to the firm, et cetera. So that you would, whether or not that's notice and properly handled as such, or it's a solicitation that could breach a fiduciary duty is an area that I don't think we want to opine on here. And so, but I wanted to identify it, and perhaps this isn't the, ideal way to identify it in that paragraph, or maybe we don't want to identify it, but it's, an issue that I think there was some sense that we should identify at least some of these other areas where there's an overlap between ethical rules and what would be maybe contractual or other legal obligations an attorney might have to consider when leaving. It's not just the ethical rules, Certainly we've taken the position that when they conflict, and if there's a contractual provision that says, you should do this, and that's clearly in violation of their ethical obligations to clients, well, they need to fulfill their ethical obligations to clients. I think that's what's said here and what people would think is the correct view. But there are other issues to consider with that. So if that's not clear, or we want to think about taking that out or revising it, I'm, definitely open to that, but that, just so you understand the context for that, that's why it was included.
Amber, can you say a little bit about why you think this?
Well, I guess one concern I would have is, notwithstanding our position that if there is a conflict, then you should always abide by your ethical obligations to your client, just having that paragraph sort of gives me as a reader a pause, and I can imagine, given the kind of cases that we've handled involving departing partners, for example, that it might give the reading attorneys, I don't know, not an incentive, but maybe a motive to kind of pull back on how, defining whether he or she is meeting the obligations to the client at that moment or not, if he or she is worried about whether he or she is in breach of a partnership agreement, for example.
But, okay. But it is true that that the thought process needs to include, the departing attorney's thought process does need to include his own potential legal exposure. That doesn't mean that controls the outcome.
Right, but why do we need that in this particular opinion? I guess I'm wondering what purpose that paragraph serves as we're dealing with ethical obligations that departing partner has.
Well, I personally think it's hugely important, because I think that that's the key fact about this particular topic, is that there is an enormous overlap between the legal obligations and the ethical, and you have to, and so, in a way, that's the sort of topic of this opinion to me, is how those fit together, and we're informing about what the ethical obligations are, but I don't think you can possibly ignore that all of these ethical obligations are taking place within the context of important contractual and fiduciary duty obligations. So I think it's important. It would be weird for us not to flag that.
Okay.
Yeah, I agree with you, Amy. I think that we'll see how the opinion reads, and maybe structurally where we want to make this point, whether it's there or in a footnote or some other place. But I think that flagging the issue for practitioners about this overlay is really important, even if we're not going to go into detail as to
And
an
it seems like
analysis.
this is the right section of the opinion, because it is the communication where that comes up. Sort of seems like that's really the big question is communication, and the way in which lawyers and firms use that communication to try to affect client decisions.
I want to just say, I think that the opinion reflects a very careful and very intelligent effort to find the place where we talk about what we really know and can say powerful things about, while not being naive about all the other factors that are in play, and without trying to take on a lot of different variants of how they could come into play, right? And I just think that's a really, and we owe that to Dina, because I think it just shows a lot of judgment about that. There's a ton of messy stuff out there,
Right.
in the case law. Weird cases like Howard versus Babcock and McFarland. I don't know what they remember the names of them all, but they're all good. They're messy and they're hard, and we couldn't really provide good or persuasive answers to how all those conflicts should be resolved. But this provides a very persuasive framework, ethical framework, to set against all of those provisions.
Right, and that point is addressed elsewhere throughout the opinion, including in the introduction, where.
It's more like we flag the points of intersection
Mhm.
or conflict without actually, and say, and the ethics will matter here
Mhm.
and should matter, but we
So-
don't provide decisive answers.
So your point, Amber, that we flag that back in
Well-
the intro, and maybe that's.
I mean, well, we do. I mean, it's sort of, beautiful kind of frames like, listen, this can be really messy, and we see it in practice. And I think that most practitioners are well aware of that fact. So I mean, I'm not articulating my point very well right now, but so I don't think that's a point of contention, or it's something that I guess I feel attorneys necessarily need to be reminded. So, and an attorney who's thinking about departing, who knows of the existence of a partnership agreement, for example, is aware.
I don't know that they always, I mean, I would argue that I'm not sure that they
That they
always
think about it.
understand the interplay between those things and the importance of certain things related to what's in a partnership agreement and ethical rules. And so, I mean, I appreciate all the feedback, of course, on that point. I think that that's what I try to do, whether, is to kind of balance that. I think it's important to identify those issues. I wouldn't want people to go into a departure and say, like, this is the only thing I need to look at. And this is going to, I mean, I think the purpose of this, well, it would be great if they did, and then it identifies other issues for them and saying, okay, I should make sure that I understand what does it mean? What does a fiduciary duty mean? And understanding that, and assuming they know that, what does my partnership agreement say? And how can I be true to all those things as I move through this? And that's the goal, right? So that that there's more, but,
Yeah, to Amy and Steve's point, and Dina's, I guess, I think it would be irresponsible not to include it, because you can't assume that people are going to be thinking of that, and we certainly don't want to put forth this impression that this is all you have to do, and this trumps, everything. There are other considerations, so I think, that whether we change the language or figure out how to fit that in a little bit better, I think it's important that it's included, for sure.
Okay.
Other comments, Amber? No?
Can I make a couple more? Sorry.
Uh-huh.
On page 5, this is very minor stuff. We say at line 185, where it says thus rule 1.1483. We just say thus under rule 1.1483, attorneys must inform clients. The reason we use the phrase ethical obligation a lot, so I'm just trying to find ways where we can change the phrasing a little bit. So it would say, thus under rule 1.1483, attorneys must inform clients about blah, blah, blah. And then in the red line at the bottom of that section that starts, in addition, the departing lawyer, there's just a little typo. Communication should be communicate.
Line 202.
Thank you.
And then one more comment. On footnote 6, my comment is I think that we might want to water the red line down a little bit. I get that we're wanting to give guidance about being careful what one lawyer says about another lawyer. But I don't know, my reaction to reading it was maybe it was a little too strong in terms of expressing the concern about commenting about other lawyers' abilities. So I'm not suggesting we necessarily delete the red line, I'm just suggesting that maybe we soften it a little bit
Don't trash talk other lawyers.
Yeah.
Well, you're
That's
saying
good
it's not,
phrasing.
it's not hard, it's not direct enough, or it's too.
Well, I'm saying, look, there might be a
Wording.
situation where, a client has a relationship with multiple lawyers, one of whom is departing, right? And the client says to a non-departing lawyer, look, if I go with, this lawyer, can they handle my case? I think that the staying lawyer can fairly answer that question. Now, in the appropriate way, right? Or you can't just say, no, I can't tell you, I can't respond. That's realistically, the lawyers, right? He's gonna respond in some manner. So I think it's good advice to say, hey, be careful not to trash talk. I get that, but I think it might be just a tad too far to say that statements pose a high risk that the information could be false, misleading, or disparaging.
Maybe
I just
just
think
What
it's
about risk, not high risk?
that would be an example of watering this down just a little bit. I just think it needs to be watered down a little bit.
Are you not allowed to despair, false, it seems like that list, false, misleading, and disparaging, like, they're one of those things that's not like the others.
No, I was trying to capture the concept from, I think maybe Amber, you brought it up or something at the last, at the last session, where the question about your obligation to say if you're willing or able to do the work, which is kind of one of the notice requirements, and can the other person do that? And the question came up related to if you were engaged in unilateral notice, right? Like there was no cooperation and joint notice, and whether it was notice by way of a phone call or in writing, that you wouldn't necessarily say like, I am willing and able to do this, but the firm is not going to be able to handle this matter. And now I doubt someone would put that in writing, but the concept being to try to have people reflect on the bad behavior about saying something and whether they truly believe that the firm wouldn't be able to handle it after they left. I'm not saying that you need to lie to a client and say, but I think people need to think about how they communicate with clients about those issues and what they say about another attorney and their abilities. And they don't know whether the firm's going to be able to get a competent person in there or what the firm's plan is.
No, I totally
They
agree.
shouldn't speak on behalf of the firm in that way. I think the response to that is, and maybe that's more of a risk management or just is just basically for the attorney to be like, well, I feel like we're better equipped here to do this. And that's what my focus would be on if I was that attorney getting that question.
Right, so
If they're incompetent, like our opinion says, that's another issue that, I wouldn't want to try to address. But we can modify or take it out. I just wanted to it's when you're talking to clients about the departure, it's sort of like avoiding those comments that are potentially could be perceived as being, they're not the same thing, false, misleading, and disparaging, but I just was trying to capture.
Right. No, I totally get that. And the two phrasings that I would consider watering down a little bit is the one, the high risk.
Yeah.
And then also the should not opine. I
Should be careful about
should be something like should be careful, because there might be circumstances where it is perfectly appropriate for the staying lawyer to say, well, I've worked with so-and-so for 10 years. To be honest with you, we haven't handled X type of matter. If the client asks if that's true and fair and not false and misleading, in some circumstances that would be appropriate. So to say should not opine, I just think is too strong.
False and misleading is ethical, and I think what you're getting at is like for fiduciary duty, contractual, intentional interference, this one's defamation.
Yeah.
If you go and say something that's false and misleading about another lawyer, not only are you violating the rules of professional conduct, but you're opening yourself up to a defamation lawsuit or another intentional interference, like we talked about in the prior. So it's another one of those ethical obligations. And by the way, don't forget there's other stuff to consider.
Yeah.
Yeah, I want people to obviously be comfortable with how we characterize it, and I'm fine with massaging it a little bit more. Obviously, there would be circumstances like where a client asks you directly about something, you would have to think about how you wanted to answer that and what you could say with fulfilling your duty to your clients to be, provide them with information.
My friend Tammy.
Okay, so I'm gonna continue with my comments, Dina. I totally echo the other comments that this is in really good shape and close to ready to get out there.
Yeah, can I make a comment? Oh, okay.
But I,
The entire comment.
I can make, I was
Oh.
doing the subcommittee and then general?
Yeah, I understand, I just wasn't sure whether we moved on to general comments yet.
No, because I'm on the subcommittee.
Oh, okay, go ahead.
Thanks. We're certainly not done.
Okay.
Okay, so I have always found, I for some reason, I made my comments in the clean, I hope you can work with that. In Roman 2, which is where we talk about everyone having ethical obligations, the second paragraph there, where we start out, because the change doesn't terminate the relationship and they need to ascertain what the client intends to do. I've just always stumbled on that. I think it's a long sentence, and I'm not sure. I don't know. I don't have a specific suggestion, but I feel like our general point is just that I'm not sure exactly what our general point there is, but it seems like there's a long lead-in and then a kind of vague point that like sort of, I'm not sure, maybe you could say what it is you're trying to get at there.
Seems clear.
Well, I mean, are you asking me to respond to that now? Yeah, I mean, I guess it's just basically saying that you're not, just because the attorney decides to, well, the focus is obviously that you're supposed to be cognizant of your ethical obligations to your clients during the transition, and both parties have those obligations, whether the client leaves with the firm or stays, and just as obviously it could be broken up into, I guess, 2 different sentences or stated, but reminding people that just because the attorney says like, or the client says, just because the attorney's leaving doesn't change their, automatically terminate the attorney-client relationship. I mean, there has to be, there's a period where the attorney needs to decide like the client needs to decide what they're gonna do. So that's just sort of a reminder of like, you're leaving and you don't just get to walk out the door and pretend like, you don't have any obligations to clients that were at the firm where you were at. So that's, I think, kind of the purpose of that.
Okay.
So.
Before we
I-
leave that,
yeah.
my small comment would be just get rid of the becauses and just start with on attorney's change of employment, and then end the sentence after the site, and then the attorneys need to ascertain, so that you break up that sentence a little bit. But
Or consequently, or therefore.
Right.
We kind of tie them together.
yeah,
The concept of, when you talk about who should be notified, the dormant client concept at the end of that first paragraph, under which clients should be notified, made me a little nervous because, and just our phrasing, because we're saying that clients that are inactive but may wish to transfer their files should be notified. And it feels a little bit like that's not.
Can you identify the paragraph or the?
Yes, as I said, the section is section Roman 2A, which client should be notified of the lawyer's departure. And the first paragraph, the end of it.
3A.
3, okay, sorry.
2A.
No, it's actually 3. Okay, I don't know. It's line 207-ish
Okay.
in the red line.
In the red line. Why is it? A, interesting. In the clean, it's, oh, I see, there, that 3 is way down there. It's 3A, sorry, guys. Okay, anyway, my point is just, I feel like we should make it a little bit more objective. Like, it's not the client's subjective, hey, I wish to be notified, because how does the lawyer know? I think we're trying to say anyone the lawyer reasonably believes might wish to transition, right?
Yeah, I mean, I just need to find out I still don't know exactly where you're.
Oh, okay.
Because you mentioned something about dormant clients and then you mentioned something about objective, subjective, so I'm trying to.
Dormant clients is,
206 on the
yeah.
red line.
Like 4 lines up from the paragraph that starts the general test. Or 5 lines down from
Oh, wait a minute.
Too right.
I think my problem, where's, oh, no, it's not, it's there.
You're right.
Yeah, okay. It's this would include notification to any dormant clients of the departing lawyer
Sure.
whose matters are currently inactive, but may wish to transfer their files.
So what are you suggesting, we should have a standard in there about
I should
the
say, I
lawyer
think it should,
reasonably leave
yeah.
if they wish?
yes.
Okay.
That makes sense.
Okay. So the conversation we had about footnote 6, the same language is actually in the text.
Yeah.
So I think I've kind of the same concern that that seems a little strong. It certainly agree that they should refrain from making false or misleading statements. I'm not sure. I think that they should refrain from making disparaging comments might be a little broad. I mean, I guess it's just a should, it's probably okay. To me, that was my reaction. And I think,
I think that concept's in that ABA opinion, but I'll look at that.
okay.
I mean, there's definitely opinions out there that suggest that you should not disparage another attorney in the part of or the firm when you're departing the firm, and whether that's an ethical obligation or just, but I think that's in the ABA opinion, and I'll look at that, and we can.
I mean, whether or not it's the ABA opinion, I guess.
I mean, what constitutes disparaging obviously would be a fact, so to say you shouldn't make disparaging comments, I guess we can think about whether that language is appropriate or remove it.
I mean, I guess just all I'm thinking about is we're talking about people's ethical obligations.
Yeah.
So the issue that we've said is we want the clients to feel they have the ability, that they have the ability to make their decision. And so that's the question, right? Is if you disparage your departing partner, are you somehow impairing the client's interest in
Or violating other ethical obligations that you have as an attorney.
like, okay. Well, if everybody else is comfortable with it, that is fine. I still, find the discussion of solicitation, I know we talked about that last time, and I know you've said that you're trying to clarify that there's notice and then there's something else called solicitation, but it seems so odd to me, because I can't make a separation in my mind between the notice where you say, I'm leaving, I'd be happy to continue representing you. How is that different from the communication that would be called solicitation?
Yeah, I mean, that's the question that makes it's difficult to navigate, right? And if you have purely client solicitation cases and other matters that don't involve law firms, I mean, you're usually talking about like solicitation versus notice, and the notice is, on this date I'm leaving this place and this is where I'm going, here's the communication. That's notice, and outside of law firm departures in general, when you're talking about issues regarding solicitation and where those provisions are valid in certain business contexts, it's easier to discern between the two. I think the notice requirements under the rule require an attorney to provide a lot more information, and it has become very challenging to navigate. And I think the question of whether you say you're supposed to indicate that you're able to continue to provide legal services for the client, and that if you want to, because if you don't, want to do that, which sometimes happens too, right? Then, you're going to indicate that you're not in a position to take that matter with you and to try to transition it, or to keep it at the firm or help them find another counsel or whatever you felt like you needed to do. And it is very tricky, because where does the line become between saying like, I'd be happy to continue to represent you and I'm willing to do that and able to do that versus, I really want you to come and what can I do to get you and where that intersects. I think it's challenging and I don't think we want to, it's going to be difficult for us to say where does one become the other, I mean, I think if you said, I don't know. I mean, that's just, I think, a question that is not something we're going to be able to answer.
I don't think we have to. I'm actually not convinced that we need this section. Or at least a full section on it. And the reason is, don't we end up concluding that, or at least with respect to current clients, I mean, there's no limit under the solicitation rules. Maybe limits under fiduciary duty or contract, but there's no limit under our solicitation rules on what they can say to a current client.
Yeah, I mean, I think the problem, I feel very strongly that it needs to be in there, and the reason is because that is constantly something that I get asked about, which is like, can you solicit clients and what that looks like?
Right.
And the problem with solicitation, because it's permissive versus notice, which you're going to argue is required, is that this is that intersection between fiduciary duties of the firm and contractual obligations you might have in a partnership agreement. And so deciding whether to solicit a client, for example, you have to make a decision about, you're permitted to do that ethically. Now, is that going to somehow conflict with your your obligations to your firm and your partners? And so I think it's important to, I don't want it to cause a lot of consternation and have people be very confused about it, but I think it's important to identify it as a behavior that's permissible. And, but I think people need to consider when they're going that extra step beyond just sort of what's generally considered to be appropriate in notice context about what you're doing, the risk that might be interpreted as competing with the firm and that the firm may, how they might feel about that and whether that's actionable and whether there's consequences for that is something I don't want to really get into, but it's a question that's asked. I think people are under the impression that they can't solicit clients.
Right.
And that could be true in certain contexts with certain clients, but I want it to be clear that they are permitted to do that. And so I'm definitely open to hearing more about that, or if people found that to be confusing or it's not helpful, but I feel like we can't at least say something about that issue here, because it's a common question.
I mean, it's a funny thing, because I guess maybe this is just me, but I think I have in my mind that this is one of these terms of art things, and that solicit is never okay. Like, that's the thing that's not allowed, and that we basically define certain things as not soliciting, or like talking to your current clients. But maybe that's just a conception that only I have. If so, then that would mean that nobody else would be confused. Yeah, I mean, I think it'd be interesting to hear if anyone else kind of stumbled over this section. And
I actually found it helpful because it is an issue that comes up from clients, and that's the term that they use.
Yeah.
So I found it helpful.
Okay. Okay, those are my comments. Open it up.
Oh,
Dave.
just, a question, a comment, and a philosophical observation. Question, this applies to all of our work. Has the committee adopted the California Style Manual as our official guide to how we write these?
Are you talking about just formatting, citation
Yeah.
formatting? Stuff? Oh yeah, don't worry about it. We usually just allow the committee to draft it as is, and before we put it out for public comment or for publication, our staff goes through it and
Oh, okay, I just
reconciles
was
everything.
curious
Don't worry.
whether
No.
that was our official, our guide.
So while you're on that point,
Yeah,
because it does help staff to make as minimal changes as possible.
right.
But Mimi's correct, we always do make all the corresponding changes. But yes, the California Style Manual is the default
Okay.
site that we go to. That's not to say historically the committee's always done that, but in recent years, we've done that. Also, there are opinions that as long as they're uniform within themselves, we've been okay with them going out in alternate style. But for the information and betterment of the committee members who are present today, as you draft your own opinions, if you can conform them to California Style Guide or Manual, that would.
Which is okay. Yeah.
No, does that mean just putting what I think of as, that means putting the years after the case instead of after the
Correct.
page numbers?
That's
Like
the
things
biggest
like that.
difference.
And
but
then
there are
also-
others.
Also, don't worry about, if you
Don't
can't
use a
find
cord.
a parallel site, because we usually, typically all the opinions have the official site plus the parallel site. So CalApp, Third, Cal Reporter, da-da-da-da. So if you can't find it, our staff will find it for you and we'll.
Oh, well, I'm a big fan of the California Style Manual, I'm pushing it. I do not get a kickback from the Supreme Court.
I need to pass that out again or something.
Yeah,
A reminder.
Okay, just a small change I think needs to be made at line, I'm looking at the red line 191. We are no longer members of the state bar, in fact, it was professional conduct, and now that even the B&P code had been purged of that nomenclature. So perhaps we should.
What line?
I'm looking at the red line, line 191. All members of the bar involved directly in this change.
All licensees.
It probably should say, well, I think the rules of professional conduct use the rubric lawyer.
Yeah, but it's a.
It's a quote.
Is it a quote?
From the 19th.
Oh, it is a quote, okay.
So that's.
I didn't see the quote marks, okay. And my last point, which is just, a throwaway. To my mind, there's no distinction between legal issues and ethical issues. And this reflects probably my peculiar experience. The rules of ethics are rules of substantive law, in my view, as opposed to things that are matters of best practice. So that's, just something that struck me in the discussion of legal issues versus ethical issues.
How would you describe the difference between saying this would be a violation of Rule 1.4 and this would leave you exposed to a claim for breach of fiduciary duty?
Well, I don't see how you could there may be a conflict between different sets of law in terms of what's required. But to me, the rules of professional conduct are black letter rules of law. That's just that's sort of the way I guess I was raised. So.
You can't get money damages for breach.
Other civil
Well, no, they're not civil rules, but they are black letter rules of law. So it's just, distinguishing between legal issues and ethics issues. It's just, it struck me, in my world, there's really no distinction. But, it's a philosophical point, not something of substance.
It helps you identify the source. You don't have to parse the difference or the similarity. You can just, ethics rules are found in one source and legal rules are found in other sources, right? I mean, I don't know that it does it detract from the
No,
analysis.
I'm not suggesting that it even needs to be parsed out. You could just say issues and not get into the distinction.
Oh, I see.
Are these legal issues, are these ethical issues?
I see.
I mean, to the extent we are applying, it's just, to me, the rules of professional conduct, those are black letter rules of law. In my world, they are. And I think in other contexts, they are as well. So, it's a throwaway observation, doesn't a lot, but it struck me when we were discussing that.
Other folks, comments? Yeah,
You wanna-
yeah, we're staying on this one until we've heard from
Yeah,
everyone.
good, okay. In the digest, on the red line, 24, I would suggest as much as possible, we're talking about clients, it should be S apostrophe. We're talking about plural, I assume. I mean, it just reads that way. So I would suggest that be made plural. Similarly, on line 76, those ethical obligations center around the fundamental concepts that clients have the right to the counsel of their choice. And then you avoid having the his or her to the extent you can.
Well, one change I had made, sorry to interrupt you on that point, was
No,
just that
no.
I think which Justin suggested in the last round was that it'd be client and its. And so I think that
Oh.
change has been made mostly in this. And
Okay.
sometimes clients are referred to in the plural, and I agree with you, there should be consistency and.
That's what I was going for, but if you've
Yeah.
already thought about it, that's totally good.
I'll just put a note and we can go through and someone can go through.
On the footnote 2, the last line, this is on page 3, there's something missing with the sentence there. It said the originating partner who's staying at the firm sometimes objects to the departing lawyer, comma, who is handling the day-to-day with the client. And then you have a dangling part phrase here, communicating with the client. Something's wrong with that sentence. I can't, I don't know if it's syntactical or the day-to-day business with the client or day-to-day tasks or day-to-day communications with the client. I don't, just doesn't read as a complete sentence. On line 130, you say it's often the case that law firms and lawyers, I think it should be always, right? It's always the case that law firms and lawyers must earn each client's continued loyalty through outstanding services.
What line?
Line 130.
It's the
Red
last
line,
sentence
130.
before
It
section.
is often the case that law firms and lawyers must each earn clients' continued loyalty. I love the thought.
We could just say law firms, like, cut out the is often the case, we could just say.
They must, yeah,
Law
exactly.
firms and lawyers
Just-
must.
It's one of the, it's a-
You know, I mean, you don't know all the reasons why a particular client wants to decide to stay or be
exactly,
with the firm, but.
exactly. Right. Okay. A couple of more comments. On page 9, part D, starting on line 351, that seems redundant to me, that paragraph. When you start the discussion of the type of notice that's required on heading 3 on page 5, you start out quoting Rule 1.4A3. You discuss ethics opinion, ABA opinion 994414. So you've really, everything in here seems to be covered. And I don't know that, it's a long opinion, so I'm thinking in terms of shortening it a bit if we can, and I think that's redundant. I would ask you to take a look at that.
Okay, I mean, I think it's trying to capture 4.1B and A3 specifically, those parts as opposed to,
Well, it certainly would,
yeah, I
could be
guess.
added to the first paragraph of, on page 5. Will you start discussing, will you first quote from the rule?
Sorry, what, I'm having a little trouble.
I think everything in paragraph D, heading D,
Uh-huh.
351, on the red line, seems redundant to the discussion which has previously been had,
Duty to communicate.
starting with page 5.
He's
I don't
referencing
know what it is.
3A.
Well, it adds information related to additional, like oftentimes you give out, you have the duty to provide notice, you give notice, and then clients ask additional information or they want to know details about your new firm. And
Sure.
I think it's important to include that you need to provide them with additional information related to rates and how matters are going to be staffed if they want that information. And so again, this is an area where some people don't think that they need to or should or are allowed to provide that information to clients. And so I think it's important to include that, whether you think it's better to put it in the very first part, of, the beginning of section 3, or take out some of the introduction part.
So you're saying that where it starts, for example,
Yes.
that's the part that's new?
Yeah, and I don't think we'd said that the rule requires the lawyer to explain the matter to the extent reasonably necessary to permit the client to make an informed decision regarding the representation. That is specifically not identified in 3.
All right.
And then the emphasis and focus on, and I think that Steve had added this part, the compliance with the request and is not something that's emphasized in that first section either.
Okay.
So those are two things that are, it's not just saying, hey, this is happening, I'm leaving, but
Yeah, there's more detail.
more detail.
Sure,
And again,
Sure.
if you, because oftentimes that happens after you've given notice and then clients will come back with questions and then you're providing information and that's okay and you need to do that is what we're trying to say.
Sanction it, of course.
Yeah.
Yeah, that's fine. And then finally, I think also on a similar note, again, I could be wrong, starting now on page 14, heading 8.
Yeah.
555. I don't know that that adds anything that isn't said.
I'm sorry, where are you?
On mine, it starts 555 on page 14.
Paragraph 4, paragraph after the Roman numeral 8.
The whole thing, I don't know that it adds, it seems to be duplicative.
The conflicts of interest section or the withdrawal by the law firm?
Withdrawal by the law
Okay.
firm or the party lawyer. Withdrawal. I don't know that that can't be shortened significantly. In other words, there's so much detail in this about the process of separation. I don't know that this adds something that's critical.
Well, I think the point of this section is under, 116 to remind attorneys that it's not just, the first two key aspects are obviously something that, particularly the first one that we've discussed in more detail throughout the opinion, but it's just the, the client file, refunding unearned fees. They're kind of going through some of the things that you're required to do under 1.16 if the attorney, if the client decides to terminate one or the other or both of that representation, that you have to comply with that rule relating to withdrawing from the firm. I can look and see if there's a way to tighten it up or avoid duplication.
Yeah, that's my only suggestion. It could be a footnote even. It's just relatively, can draw lawyers' attention to it. There's nothing wrong with that. Okay, that's all I have. Wonderful job.
Yeah, it's a good.
Really thorough. It's wonderful.
Thank you.
It's very
Thanks for all
helpful.
your feedback.
Anyone else? I'm sorry, I have one thing, Dina, which is just on your list of things that the notice should say, there's one of them that's just not parallel in form. So you say the notice should inform the client, and it's kind of the one that is not parallel is make clear that the client has the ultimate right to decide. You just need to shift it into, I think if you just take out make clear, that probably,
Yeah.
Thanks. So I guess, if, we didn't give you a whole lot to mess around with, but maybe enough to do one more revision, and then we can hopefully kick it out next week, vote it out, see if we can vote it out next week.
Okay, for the next one, yeah.
So this is gonna be one of the mandatory opinions.
Yes, yeah.
I'm just gonna make a note.
Yeah, that makes sense. And then Mimi, you'll send me those comments, okay? And then if anyone has any additional thoughts sooner, I would like to gather all that so that I can make these final changes and not revisit other issues. And I'll hopefully balance that. Not that you can't revisit them, but
Think about also in the digest, whether there should be, especially where we're striking a lawyer wants to leave her firm, starting out the guiding ethical principles that govern is a little abrupt, and I wonder if you want to say a lawyer's departure from a firm or other employment involves ethical considerations or some sort of general throat clearing kind of thing. Just a thought. Okay. 20 minutes. Shall we talk about ancillary business? Because hopefully we can do that quickly.
I don't think we're gonna be able to do it quickly.
Okay.
And let me explain why. I got some very good comments. I'm about to send you something which I'd like you to put up
Sure.
if it could. Did you get, maybe you have Randy's,
Would you like me, there's
No, I'm gonna
comments?
ask you to put that, yeah, I think we should start, let me just describe the problem. Andrew and Randy are concerned about a passage in the opinion, where is it in the red line? I'm sorry, I've been so busy trying to revise in response to their. Yeah, why don't you do it? Why don't you, Andrew, why don't you do it?
I have a couple concerns. And the first being the ability to disclaim for non-legal, so we have two topics that the opinion is addressing, right? Providing services that are non-legal in nature and providing services that are non-legal in nature but are fiduciary. And I'm uncomfortable about the fiduciary piece of it.
Right.
And there might be disagreement as to why, but if we're going to make this distinction, I think we need to do it's a heavier lift to say that you can disclaim the application of the rules of professional conduct in a fiduciary capacity.
While running a non-legal business that involves the assumption of fiduciary duties.
Right.
Yeah.
And that might be the case. Personally, I'm not comfortable with that. I wouldn't prohibit the opinion going out, but if that's going to be the conclusion, I don't think that the opinion as currently drafted sufficiently makes the case that that's permissible. And the reason for that is and I don't mean to be too quick to describe it as such, but essentially we're saying, well, the opinions never, the cases that say the fiduciary duties apply never consider that you could disclaim them. Therefore, you must be able to disclaim them. And
That's not
That's a
quite
little
what they
rough.
say.
Okay, right.
But I
That is
take
my
your point.
inference, right. And
We don't adequately explain. That's
Thank
the
you.
basic point.
So there's that, and then the other thing about the obligation, we need to make clear that these are not current or former clients. I'm not sure the opinion does that throughout. In some places it muddies it a little bit. Because some of the cases that we're citing, that the fiduciary duties, the fiduciary services that are provided require the application of rules of professional conduct are attenuated to the fact that the lawyer previously or currently is providing legal services to those individuals. And so if we're going to come to the conclusion that you can disclaim you can disclaim the application of the rules in a fiduciary capacity, I think we need to make clear that in our hypothetical, these aren't current or former clients. That's just my personal view. And then those are the two main issues I personally have. And then there are other wording changes, and then, as you noted, Randy provided, as always, more persuasive and thoughtful comments than
Right. Randy has a number of comments, and I want to put them up.
Do we want to
Shortly.
pass out his draft?
You have copies?
Yes.
Yeah, I didn't know if you wanted to.
I loved Randy's comments for
Sure.
the most part. I thought they were very pointed and improved the opinion from what I could see. But we should all look at them.
Yeah,
Should we,
Yeah.
Maybe review it over lunch.
yeah, should we break now? Let
But-
everybody read Randy's comments, have lunch, and then come back?
Figure out where that high pitch
What
voice
time
is
is
coming
it?
from.
Or move.
That'd
I don't
be
think
fine. Or I can show you.
Just wanna
But
tee it up.
I'd like to show you a little bit. And you send this to me.
Drive me crazy. Yeah.
Yeah, what is that sound? Now you call my attention.
Sorry.
That's really weird.
Yeah, there is an annoying little.
Yeah.
I should have, I didn't mean to make you hear that too, but. Really annoying.
If we close the door, it'll be better.
Oh, it's over there? Okay.
I do not understand.
Boy, maybe they should,
Crisis averted.
crisis averted indeed. Yeah, that would have been a bad afternoon. Yeah. Like when I can hear my son's sound machine in the other room, it drives me crazy.
Steve's
I
is
tried to
sharing
send you
a
some.
document.
Which one are we reading?
Well, I guess
This one with the red line, and some of these comments.
I'll just describe my thoughts without putting language up at this point, and then you can read Randy's comments. The specific thing that Randy and I think Andrew are concerned about is that is discussed in the red line, and it is around the question of whether language in the in some of the cases and opinions, including our prior opinion, said they say there's language that says there's language that says
What line?
yeah, I'm at 273, the red line.
On the version?
Yeah. Formal opinion 1995, 141 states without apparent qualification that when rendering professional services that involve a fiduciary relationship, a member of the state bar must conform to the professional standards of a lawyer. That language also shows up in cases like Erie versus State Bar. And there are others. The question that is flagged here, but which Andrew presses, is whether that language actually bars the kind of regime we're talking about for a lawyer who's doing a non-legal business as a fiduciary. Right? So suppose you decide you want to be a professional fiduciary, a heavily regulated field, and you go into business with another professional fiduciary. Can you put out, say, I'm a professional fiduciary, but I'm not a lawyer, right? So, for example, the effect of that, in our opinion, would be that you wouldn't be bound by lawyer-client confidentiality, which might be a pretty inconvenient thing to be bound by if you're a professional fiduciary. You might want to actually not be bound by it. The implication of this sentence is that you'd always be bound by lawyer-client confidentiality, even if you weren't providing any legal services at all, even if you disclaimed, right, that you were providing any legal services, right? That's one way to read that language. Another way to read that language is that it doesn't prevent somebody from moving into a different regulatory regime just because they're a lawyer, provided they make clear that they're not acting as a lawyer. That's the sort of choice. I think that we can do a better job of explaining why that language in cases like Bury and others doesn't prohibit it, but essentially there are three arguments. One is that some of those cases actually involve a lawyer-client relationship. Bury itself involves a lawyer-client relationship, and that one is found by the court. Like a present lawyer-client relationship is found to exist. So the language is dicta in Bury, totally. Right? A second is that in a number of these cases, the discipline that's imposed is expressly imposed under 6106 for moral turpitude. And a thrust of our opinion is that you're always subject to discipline for moral turpitude, whatever you're doing. You can be subject to discipline even if you're not engaged in business activity. So that's not really a point about whether you can disclaim duties that don't involve moral turpitude, right? The third would be, so there's some universe of cases that's left, right? Don't involve a lawyer-client relationship, don't involve moral turpitude. Do those cases stand for the proposition that you couldn't ever step outside the lawyer regulatory regime? And I'd say no, because in fact, they involve conduct that we would clearly agree would prohibit any step outside. That is to say, they involve conducting your non-legal activities in the same matter, in the same office, with no distinction. Or they involve chatting up the client on the basis of your lawyer skills and your lawyer trustworthiness. Often there's a kind of a situation, a lot of the cases involve somebody who's like dealing with the mother of their law partner, or things like that. There are no cases where somebody is saying, this has made a distinct business and has given the required warnings. So the argument would be, how can you read this language, right? Given the nature of the cases where it's been used, how can you possibly read this language as reading on the question that we're interested in, which is, can you, if you're in a non-law business, admittedly acting as a fiduciary, can you conduct that business under whatever legal regime applies to that kind of fiduciary, right? if you are running a distinct business and if you've explained that you're not practicing law. That's the question. I think I can beef it up to make that point clear, but the committee will have to be happy with that. And hopefully, if the committee is happy, Randy and Andrew will be happy. That's the issue, though.
Yeah, I guess the other point, just to ruminate on over lunches, and I don't take issue with how Steve describes the case law, but in many cases, I could think of 4, and there might be more than 6 Supreme Court disciplinary cases, they have this sentence or statement said in so many words. When a lawyer is providing services in a fiduciary capacity, notwithstanding the fact he's not acting as a lawyer, he is held or she is held to the standards of the legal profession. And if we're going to make a distinction there, I just think, and I know this is what Steve said, I just think we need to state a more compelling case. I think also it would help the opinion if we had a heading, non-legal services, and do the analysis there. Non-legal services involving a fiduciary relationship, and do the analysis there. We conflate a little bit those two services being provided throughout the opinion. I don't think, for me as a reader, the distinction is not clear. And then secondly, the example you gave, which is the one case I printed out, Worth versus State Bar, attorney provides investment advice to his law partner's mother in a real estate deal. No attorney-client relationship, which is what you I believe, are stating is the distinction, necessary distinction in Beery for part of the analysis in our ethics opinion, but nonetheless, the court still, retains such language. The lawyer who accepts the responsibility of a fiduciary nature is held to the high standards of the legal profession, whether or not he acts in his capacity of an attorney.
Isn't it worth a 6106 case? I'm not sure.
I'm sure you're right. I'm sure it's cited, and if that's the distinction we wish to make, I just think it's not. I think the opinion is not strong enough to. I wouldn't want to mislead lawyers that they can engage in these activities without taking greater care, and we also need to protect clients. Clients who are working with lawyers might unreasonably expect that the lawyer is acting as an attorney by virtue of their existence as an attorney. And I know we touch upon it through the opinion. I just wonder if we could have more marked headings to discuss these distinctions throughout. So it's a little more, the analysis is more clear as opposed to a running discussion. And I don't mean that negatively. I think the opinion's strong and good. I just think we need to separate non-legal services generally, non-legal services that are fiduciary, and need to make clear there's no attorney-client relationship with any of these prospective clients, currently or former, because as you alluded to, many of those cases involve that fact in which the rules of professional conduct are applied to the lawyer acting in a fiduciary capacity. Anyway, that's generally some of the concerns I have.
Can I ask a question? Would it be helpful if Steve's right, that the distinction, that it's a moral turpitude issue that we said again, even though we have said it earlier, that, that to be clear, the lawyer, any lawyer at any time is always subject to 6106.
Right, that would certainly help, yes. And I agree, it's in there. I don't know, for me personally, I don't know it's stark enough.
Yeah.
But yes, that would be something to help. If I'm being totally honest, I think if this opinion was just on non-legal services and we don't touch upon the fiduciary issue, that would be super helpful and great. We would have great standing to do that. When we go into the fiduciary area, I'm not trying to say we can't make the case. I just don't know that it's well settled. And I'm very concerned about disrupting the folks on the 7th floor here who are imposing, who are tasked with regulating lawyer conduct, and we'd be undermining a central tenet in Supreme Court case law about.
if I'm right, and you guys will have to decide if I'm right, that in fact, that principle has never been necessary to a decision, right? And in particular, that it's never been applied in a situation where a person played by the rules, that is to say they had a separately non-legal business and they made it clear they weren't practicing.
If we had that example, that would be great. I think that would help.
Well, I'm just saying though, the fact is the point is that what we're saying is it's not central to it's not, because in fact, all the cases that they've used it, right, they either don't need it, right, or they don't involve the kind of situation that we're talking about.
Mm-hmm. Okay, so
this wouldn't change the result in a single case.
Because you're saying every case that the lawyer who is disciplined for acting as a fiduciary, see, I'm not sure 4100 or rule number 9, former rule 9, which I think is 4100, current rule 1.15. I think some of those cases, I think Worth references the obligation to hold, he was holding his law partner's mother's money and he didn't account for it. He's saying, well, I wasn't acting as a lawyer. And the court, those opinions are 3 pages. There's not a lot of discussion, but nonetheless, and I have the case printed out.
But Worth is also a case where this guy, actually, it looks like he performed some legal services if you read the opinion. Somebody incorporated the business, but in any event, he was clearly using his lawyer status, and there was not distinct from the practice, and so he wouldn't get the benefit of our rule. That's, I think, the point, is that nobody who's been disciplined under a decided case would get the benefit of the rule we're proposing.
One other point to consider, Andrew, is that there is currently this sort of other push towards access to justice issues. And these sort of notions of the ways in which lawyers can be more flexible in the services they provide is a current sort of interest, and it also is consumer protective as well in a different way. So there's just a tension, right? And this would be so it's not without, it's not just like we're just taking away a protection and not achieving anything.
Sure. No, I agree, and I understand that. And Steve in his presentation today made the point, and I'm not sure I see it as clearly in the current draft, lawyers acting as a fiduciary but not as a lawyer subject themselves to the regulations of that profession. I mean, maybe, I'm sure it's in there, I just don't see it as clearly stated. We could say clients are protected in these instances because the point you just raised. I think that might be helpful.
I think we do say something about that, but we haven't talked about it in detail.
Mm-hmm.
And I'm not sure I'd want to make that claim always, but clearly for professional fiduciaries, it's
generally,
true. Real estate brokers, it's true. And when I actually, a few years ago, had to look at whether we wanted to attack the conduct of a lawyer / real estate broker as a lawyer or as a real estate broker, we thought the rules were tougher on real estate brokers in this particular situation. So, I don't think it's just not the case that there's only one virtuous place to be.
Can I make a comment? To me, the issue, and maybe it reflects my naivete, is it our job to say what the law is, or is it our job to say what the law should be, given current, and Amy's your comment about access to justice issues? Is there social utility? Is that the purpose of this opinion, is to allow lawyers to provide services in a context to meet those access to justice needs without being unduly restricted or regulated? I don't know the answer, but I've often wondered, and I know in San Diego we've had this debate in our legal ethics committee. Are we articulating what the law is with an eye toward a conservative statement, or are we articulating what the law should be or might be in the face of perhaps insufficient authority, given the necessity to advance a public policy goal, access to justice. So I don't know the answer to that, but I've often wrestled with that question in our local committee.
I think it's a good question. The way I conceive of this is that we're lawyering here. We're not making it up, right? We're lawyering, and the techniques that I just described, right? Asking whether a particular proposition is necessary to a court's decision, right? Or whether the case is factually similar, right? Or whether the rule we're announcing would change the result in a decided case. Right? Those are classic lawyer techniques for deciding what the law is, not techniques for deciding what the law should be.
Well, I'm sympathetic to that view because I think my position has always been we're making law here, even if we don't really say we are. Just by articulating what the law is, essentially we are making, and we are formulating an opinion that, although not binding, will be persuasive and of guidance, and to the extent we are making law too. I'll say some members of my local committee don't like that idea very much, but that's always sort of been my attitude. But I think, Andrew, your point is well taken, and I think, Stephen, I think I might have mentioned this to you, that from the point of view of the Office of Chief Trial Counsel, that this is probably not going to, they're probably going to have a lot to say about this opinion and where we go with this. If we go there, that they will definitely have something to say about it. Randy sort of, I think, give us a preview of that.
I'm all in favor of
That's
writing
a
it.
good point, is that that maybe that makes sense to publish it kind of as is, maybe a little tweak, but it's not final, then we're gonna get comments. And
Which I think we should generally do more often than we do.
Yeah,
We should throw stuff out there. You know, even recognizing that we may have to make major changes in it, right? Depending on what comes back, or we may have to withdraw it. But there's some value in putting things out there that advance the debate, and then seeing whether I'd like to see the Office of Trial Counsel's best analysis of why this is wrong and hurtful, because I'd like the analysis, like if they can come back and say, no, this is really changing the law in a way that's bad. But my thinking right now is, no, if a professional fiduciary explains, I'm a professional fiduciary, yeah, I have a law license, but I'm a professional fiduciary, I'm gonna operate under those rules because I'm not your lawyer, right? And if the state bar, or if the state bar prosecutor wants to explain to me why that's bad, why that hurts them, right? I'd be interested, because I don't see how it does.
Well, there's,
okay, but you know what, I'm gonna
Yeah,
stop
stop.
right now.
yeah.
Please, just because I understand how you phrase it, but I would phrase your last statement, how you phrased it. I phrased it a little bit differently, Mayor. I honestly think the burden is on us to show why these unequivocal statements going back to the 1950s and repeated Supreme Court discipline cases are amendable.
Okay, all right.
And if there's a case for us to make, we need to make that case. You can't just say, show us why we're wrong. I think the burden is on us to make that case. And I don't know that we've done that.
Okay, all
Okay.
right,
So that's
we're
my
gonna,
advice.
we're gonna stop here. We're
I'm
gonna
gonna
break
send this to you.
till 1. Does anyone raise their hand if they feel that they don't have enough time to digest their food, do what they need to do for work, and read Randy's comments? No? Okay, good. That's what we're doing. No, you can do it in any order you choose.
We'll start with the clients.
Yeah.
The latest flight for me today was 4:40.
Okay, fine, so you
I'm
need to
gonna
get
have
out
to-
of here like 3:40 or even
No, I gotta
earlier,
take
probably
Barton all
3.
the way down.
All right, well, whatever you need to do.
If
So
you can-
does that mean you want to do yours next after
love to.
Steve? You got it.
I'd like to, I don't think it'll take that long.
So Andrew, let me show you what
know,
and very harmful to the sort of benefits of this opinion potentially from a public policy point of view. I'm happy to talk about that more. Other things I think could be, there he says sort of this argument could be strengthened, so forth and so on. I'm quite open to a lot of what he has to say. With respect to the sort of core question that Andrew advances, Mimi, if you could pull up the new version.
I did.
And focus it on the changes in the discussion of, I hope people will be able to read it.
On the version.
Andrew basically said, here we go.
Okay, let me make it so it's all on one page,
That's totally cool.
so you can see it.
Oh, okay,
So this is under clarifying, effectiveness of clarifying measures, section 2.
right, so this is at about 260 or 270 of the current draft. And so Andrew, to paraphrase Andrew's point in a way that I hope is fair to it, he's saying, and I think Randy has this concern as well, he's saying, look, there's this language in Opinion 1995-141 that states that when we're rendering professional services that involve a fiduciary relationship, a member of the bar must conform to the kind of professional standards of a lawyer. And point one, I think, that's being made is, Bundy, that's just understating the issue, because that statement also turns up in a bunch of California Supreme Court opinions, which of course the 1995-141 is quoting from. And an example would be Beery versus State Bar. So we go on and say, well, that language could be read as suggesting that essentially our regime, which is if you have a separate non-law business and you've made disclosures that you're not providing legal services, you're not a lawyer, you're not a lawyer, not providing legal services, there's no attorney-client relationship, no privilege, etc. If you've made those disclosures, we'd say you're out if you can be, your services and your provision of those services you can do it as if you were a non-lawyer, essentially. And but you could read that language as saying you can't do it. So here's how I tried to beef this up. So we do not, however, read the opinion or the other authorities containing similar statements to acknowledge that the case against our position is harder than it appeared earlier. We don't read it that broadly. And that point one is, some of these cases actually involve the lawyer-client relationship. So the fact that the court says you can be disciplined just as if you were a non-lawyer is total dictum, because they were lawyers, and they get in a lawyer-client relationship. Second, in other cases, the statement was unnecessary because the discipline is under 6106 for fraud, moral turpitude, right? And we're not claiming that you can ever claim that. That's something that's going to be available against you in any business you could possibly be in. So then the third is, none of these cases, this is the point that was made earlier, none of the cases involved a non-law business distinct from the lawyer's practice, or a lawyer who made it clear that no lawyer-client relationship was being formed or legal services provided. So in other words, the separateness and non-disclosure pieces, which are the key to our proposed ability to disclaim, were never present in any of those cases. And in fact, to the contrary, these are almost all cases about people operating in law and non-law business out of the same office or out of the same hip pocket, right? And using like crazy their status as a lawyer to try and show what a good deal this is. So come down then, if you flipped it, Mimi, if you could move it down a little bit further. So then the argument would be, because none of these cases presented a situation involving professional duties that could be disclaimed, a distinct non-law business, and appropriate clarifying measures, none can be read as addressing that situation. All right, and then for similar reasons, the approach proposed here would not change the result in any of those cases, And as shown above, it is consistent with other principles governing the formation of an attorney-client relationship. And then move into the policy point at the end. That may not be the strongest version, but it's a stronger version. And I think we don't have to decide it all today, but one question is whether people are persuaded by that kind of sort of broader, more nuanced statement, that we're comfortable with the idea that somebody who, for example, is a real estate broker, lawyer, real estate broker, working in a real estate brokerage business, can function just as a real estate broker. Does not have to comply with lawyer trust fund rules. Does not have to comply with lawyer-client confidentiality rules. Does not have to comply with rules, other rules that might potentially apply, but can instead just say, okay, whatever the rules are in my brokerage firm, those are the ones I'm going to follow. That's the question. Because brokers are a form of fiduciary. That's all I want to put out right now, and I'm really interested in hearing people's views.
That's a good question.
Yeah.
So is that the essence of what you're trying to achieve here? To expand on the previous opinion, I forgot the number, the one you cited at the beginning, our opinion.
1995-141?
Yeah, so you're taking it the next step. That involved a investment advisor, which is a fiduciary as well, it seems. So are you taking it beyond that to describe scenarios where there's an attempt to disclaim, and then when are those disclaimers effective? I'm unclear about why, as I'm reading this, why are we writing this opinion? What is it adding, that the 1995 opinion?
Well, I think it's adding something important, and other people can speak to this based on their own conception. California, unlike most other states, does not have a very clear set of principles about when a lawyer who's engaged in a business that could be mistaken for the practice of law, right, is subject to professional discipline. And for conduct that goes beyond moral turpitude. Everybody's subject to discipline for moral turpitude. Right, yeah. So the question of what about the other rules of professional conduct? 1995-141 is a very good statement of the law at the time, but it doesn't have any way for a lawyer in this gray area to clarify precisely what legal regime they're operating under, right? So, this is designed to provide that, a mechanism whereby people can clarify what regime they're operating under, and the theory behind that is a sort of a fairness efficiency theory. That, why should somebody who is a lawyer carry with them all of the different features and inefficiencies of the legal regulation into a field where they aren't relevant?
I agree with that. I guess what I read the former opinion as saying that to the extent that there's any risk that a reasonable client could be misled based on the facts, advertising, location of the offices, all the rest. To the extent that a reasonable client could be misled, that's what raises the dilemma and puts that under the umbrella of the professional rules. I'm not sure, why doesn't that principle still apply to these scenarios? Why isn't that a sufficient answer? Say, if to the extent the client isn't misled, or there's no risk of the client being misled, why isn't that the touchstone?
That is the touchstone. Read the last sentence of the paragraph. Put simply, once appropriate measures have been taken to avoid consumer confusion, there does not appear to be any good reason. So we're just talking about what's required to avoid consumer confusion. We
guess I'm
say
not-
one thing is that the businesses have to be distinct so that it doesn't appear that they're functionally overlapping or so forth and so on, right? The other is that even if they're distinct, right, you've got to take reasonable measures to ensure that people understand that, hey, what I'm doing here is not the practice of law. You're not forming an attorney-client relationship. Most important probably to most people, you aren't going to get the benefit of my ability to not testify against you, right? And so forth. So that's what we're saying. We're saying that's what we mean by appropriate measures have been taken to avoid customer confusion. So that is the touchstone still. We're just saying that there are situations where a lawyer can take measures to eliminate customer confusion.
So that's what this opinion, here's examples of what a lawyer can do to avoid confusion.
That's the core of the opinion, is the
I think that ought to be said at the very beginning as a thesis paragraph, or a thesis sentence at the very beginning. It doesn't quite capture that. The digest doesn't, I don't think. There's this opinion.
Excuse me, maybe I'm just totally missing it.
Where am I missing? What am I missing?
I'll just read you what we have. I'm happy to change it, but
Just give me a line.
yeah, it's like 28 and 29, 26.
Okay.
Right, you may start at 23. Although non-legal services are not the practice of law, can be subject to the rules of professional conduct if they're not distinct or they are sufficiently law-related to give rise to a reasonable risk that the customer may understand that legal services are being provided or the lawyer-client relationship has been formed. Isn't that the substance of exactly what you're talking about?
I guess as I'm reading past opinions, they tend to build on previous ones that are on point. So I guess maybe it's a minor point, but I think it would be more consistent with that tradition by saying this opinion builds on opinion 1990, I forgot, 1999. Or,
how about footnote 1?
I guess it could go in the footnote, yeah. Okay.
Justin, I saw you had your hand up.
Yeah, so I think that it's a good tool to try to distinguish the cases in support of the position that we're taking. So with that, I understand the
concept and agree with it. Where I think we could reinforce what we're trying to do here in terms of persuading that this formal opinion 1995-141 quote needs to be distinguished or read in a different light or doesn't apply here, is to grapple a little bit more or grapple with what this quote actually means, which I find to be very vague.
I think that's a terrific point.
If you look at 1995-141, this, where I'm really hung up on is this phrase, professional standards of a lawyer. What the heck does that mean? Are we talking about the rules of professional conduct? Are we talking about fiduciary duties or something else? This 1995 opinion, that phrase professional standards of a lawyer appears once and it's never defined, it's never explained. There's no context. So I looked at on our break very quickly. I do not have the definitive answer for what does this mean, professional standards of a lawyer? What are the cases talking about when they use that? At least in the Alco case, in referring to that phrase, it then talked about the standards of honesty and good morals, which has, in my view, nothing to do with the rules of professional conduct or fiduciary duties.
That sounds like 6106, doesn't it?
Right. So
if there's something that we can do there in terms of looking at this particular quote and how it's, and how professional standards of a lawyer is used, and say, given how that is actually used in the cases, whether it's because it's 6106 or otherwise, to help with our persuasive point. I think that we should grapple with what that quote actually means.
I think that's terrific, and that would be very helpful. And it may well be that that strengthens the point that this is more, that the focus is really on 6106 type situations. Relatedly, do you think it would be helpful? I mean, this has been running through my head, but I haven't. To say, look, it's one thing to say, this language can be read that way, right? Be read in a very strong way as saying this is an absolute rule, but it could be even stronger. It could say, and no one can ever disclaim this, right? And we don't have that second half of the sentence, right? There isn't something that says you can never disclaim this or never clarify or never make something that so it doesn't have quite the force that way either. So I think that your point, and maybe this is second point that I'm just articulating, are worth putting out there as ways of helping on the just sort of the textual analysis of the phrase, right?
Tina, then.
Let me put my microphone. I completely agree with Justin's point. I was kind of trying to grapple with that last sentence and the example that you gave when we were talking about, do we agree conceptually with this idea here that we're putting forth in the opinion? Your example there was like this real estate broker, and I feel like that example that you said, there's a real estate broker, this person works in a real estate office, should they have to comply with IOLTA rules, attorney-client privilege? I think some of those things to me seem very clear, like of course they shouldn't have to do that if they're not, they happen to be a lawyer, but there's nothing else about them that says that they're a lawyer, again, unless that's advertised in that way and there's confusion, and if they disclaim that. I think the hypothetical in scenario one, and I think you do a really good analysis about how you can have clarifying measures, so I'm not suggesting that be modified, but maybe the hypothetical, which involves fiduciary services, there's a law firm, and they're somehow involved, but not, that seems a little muddier to me on that point. And I know you want to include the concept of a professional fiduciary as well as.
I want to put somebody in there who's a fiduciary.
Yeah,
so we can get some, doesn't have to be a quote professional fiduciary, that's a specialized term.
Yeah.
Right? It could be a real estate broker.
Yeah. Because I feel like that to me seems more, I agree with that. I think just because you happen to have a law license, if you wanted to do something totally different, why should you be subject to some, and I think the question of exploring what professional standards, that's a very good thing, because to me, I feel like, clearly all of the rules, and IOLTA is a very good example, are not going to apply in certain situations to people that are not practicing law, right? But there are some rules that maybe would, and you try to separate those. So I think that's a very good area to focus in terms of distinguishing between those. But I just felt maybe the hypothetical could be a little bit different, or maybe using a different example. I don't know. It just seemed too much of it was unclear to me whether there was a little bit muddier with the lawyers owning that, and it was like part of their business, but some non-lawyers worked there and some lawyers worked there, and whether the people that, whether people would be concerned that there's too much overlap there to have any kind of clear distinction. I don't know.
Right.
Steve, what I was going to raise is perhaps one of the things you may want to consider is, a lot of the rules, as a matter of fact, probably most of them begin with a recitation, this applies only to legal services, or this applies only to fees received for legal services. And so have you considered, or would it be appropriate in your view that a best practice, certainly not required, would be a disclosure, preferably a written disclosure, or an understanding with the client that lifts it out of the legal services and legal fees realm. That would lift it out of most of the rules all by itself. Some of the rules would stick. There are some that apply to a lawyer's conduct, whether or not the lawyer is providing legal services. One that comes to mind is client trust account, dealing with other people's money, whether it's a third party's money or that's a kind of thing that, again, a disclaimer or an agreement with the client about how these things are going to be handled other than as a lawyer. So
But that's, I think I'd be worth, that's exactly what I think we're talking about, is something like that. Now, I know the client trust account rules as well as I should, but I would think that one of the big things that a real estate broker would not want to do is to be subject, because they have lawyers working in their office as brokers, they would not want to have to establish client trust accounts. And I don't know whether the text of the rule would call for them to do so or not. But that's exactly the kind of thing that I think we're wanting to allow people to contract out of, is the risk that might be, somebody might say that.
Oh, exactly, that's why I'm saying.
Because it's a separate business. Now, it'd be one thing if the lawyer is running, on our analysis, if the lawyer is running a brokerage office and a law practice out of the same room, right? They probably are they may well have to use their client trust account. I mean, I haven't analyzed that separately, but our assumption is that that might be something they might well have to do, right? But if the lawyer is sitting over at Coldwell Banker, right, and has their law degree on the wall, but otherwise doesn't do anything that a broker doesn't do, hopefully not.
So that's what Worth, that's the exact point Worth says, Worth versus State Bar.
But Worth is not, there's no distinctness there, and there's no warnings. Isn't the Worth the case where the guy swindles his partner's mother?
An attorney who accepts the responsibility of a fiduciary nature is held to the high standards of the legal profession, whether or not he acts in his capacity of an attorney. He must maintain proper books of account and records of transactions, and he may not commingle clients' funds or use them for personal purposes.
I guess what I want to say is that that's okay. First of all, there isn't any, I mean, I'm not hearing any response to the point that he basically used his position as there was no clear distinction between his lawyering and his other business, right? Plus, and he didn't give the disclaimers.
Correct. None of these cases give the disclaimers. So we're never going to find that.
None of them involve distinctness either.
Well, I'm not sure, because initially you state, well, all these cases, or at least some of the cases, a lawyer-client relationship exists, making these statements unnecessary to the decision. No attorney-client relationship exists in Worth.
I understand that.
Included.
I'm working them down. But I think I covered every case before I got to the bottom.
Sure.
There are more distinctions for some than there are for others, but there are good distinctions for all. I think the statement at the bottom that says none of these cases speak to this situation is correct. And I think the further point that nothing we say would change the result in any of these cases is also correct.
Well, the other thing I would point out is,
I mean, I'm open to being shown that that's wrong, but I'm not saying that all these cases fit under any one of these three rubrics. I'm just saying that at the end of the day, none of them speak to our situation.
okay, I might disagree with that, but to the point where your added language, says, in some there was in fact a lawyer-client relationship, making the statement unnecessary to the decision. 2 points about that. There are some cases in which there is no lawyer-client relationship. Nonetheless, they include these statements, and so in the email I sent to you the other day, it just seems weird. If it's unnecessary to have the statement because a lawyer-client relationship exists, I don't know if we can wish away that these statements are contained repeatedly in disciplinary case law. And then the last point I would make, because there is a lawyer-client relationship in some of these cases, I think this opinion would need to take care to show that we're not applying this to a current client situation. I know you want to introduce that concept. Personally, I'm not sure we can get there. And second, I think that's going to create a lot of confusion, notwithstanding the sophistication of the client. If you had a client who had a lawyer and was representing them in a legal matter. At the same time, the lawyer was representing them in a non-legal matter. Does the lawyer have to stop and say, for the purposes of this discussion, I'm talking about selling you boats, and I'm not talking to you about your legal matter, therefore, I'm not your lawyer for purposes of this conversation, and vice versa. There's a policy concern and, quite frankly, terrible results, a parade of horribles, which could maybe come out of the statement saying something with respect to a current client relationship. And so, to the extent we're comfortable talking about disclaiming fiduciary relationships at all, I think we need to be clear, it is not okay in a current client relationship.
Andrew, that's very explicitly discussed. We say, in the discussion, in the third paragraph of the discussion, we say, if a single lawyer is offering both legal and non-legal services in the same manner from the same office, the activities will ordinarily not be distinct. And then on the other side pole, there's the different matters and separate entities. And then, so the point is of this opinion is it's not that we're not willing to say that under no circumstances could you ever have a current client relationship where you took measures sufficiently that you could provide the non-legal services and have the rules not apply. There's definitely the presumption in the circumstance you say that the rules will apply to the non-legal law-related services because almost certainly it won't be distinct enough and the client could be confused.
Okay, but then you get to line 222, and we say, in some situations, particularly those involving the provision of legal and non-legal services in the same matter or to unsophisticated customers, the legal and non-legal services may be so closely intertwined that even a very clear disclaimer may not be effective. And I understand that that's the point you're making, but you're introducing the concept that it's with respect to an existing client. And I think the opinion is not clear, the situation we're talking about, existing client, existing legal client or not. And to the extent we're talking about an existing legal client, I don't know what authority we have. I think that's more fraught with peril than even trying to distinguish the fiduciary cases that we want to talk about initially.
No, I don't, Andrew, I mean, look, I think, I hear your concern. I
Like
mean,
you
I
tuck that
think,
in at the bottom of a very dense, long, heavy paragraph. I don't know an uninitiated reader is going to appreciate that distinction. I think we just need to be clearer and sharper in the analysis we're taking. And notwithstanding the point that, yeah, for the record, I'm uncomfortable with the concept that a current client can receive such disclaimers with respect to the fiduciary.
well, let's think about it though. Would you want to bar ever, see, let me give you an example, Suppose the law firm represents a company in patent litigation, all right? It's a medical device company. Okay, it's a medical device company, they're represented in patent litigation. The law firm also is the majority owner, and some lawyers from the firm work there, in a company that is a sort of healthcare consulting business that talks more generally about, trends in the healthcare industry and provides advice and so forth and so on, right? It's not a law business. It's an advising business. You think of them as the kind of McKinsey of healthcare, right? But it's close enough to lawyering because they talk about policy and they do stuff like that it falls into the category of law related, right? Are you telling me that firm, the second firm, client comes over, they're a client of the law firm, right? They want to talk generally about how to position their business. And the consulting firm says to them, we don't actually practice law over here, right? And you're not forming a lawyer-client relationship with us. There won't be any privilege, right? And we're not providing legal advice. And guess what? We're just consulting with you. can that, you're saying that law, that client can't sign an effective, can't opt out of the rules of professional conduct?
So for me, what I'm saying, and it goes back to David's point before we broke for lunch, I don't think an ethics opinion is the appropriate venue to resolve my personal belief, advising this committee for many, many years, that it's going to be very highly fact specific. It's just not appropriate to resolve such a weighty policy issue
why-
in an ethics opinion.
You know what,
Can I ask a
then
question?
nobody can resolve it.
Without more,
But then nobody can resolve it.
without
It's just-
more authority.
Wait, with deference, isn't this exactly what the Rules Commission wanted to have happen? This is exactly what they wanted because they didn't pass 5.7. So how are we gonna have guidance on this?
So I would be happy.
Only by
if we-
people being sued and disciplined?
I would be happy if the opinion was limited to non-legal services and we don't talk about the fiduciary issue. And we
Fiduciary
don't talk about
services
current
are
law.
non-legal services.
Can I ask a question? Just to clarify my understanding of the debate a little bit.
Yeah.
Andrew, what I think I hear you saying is that where the lawyer has previously provided to the client legal services, or is simultaneously providing to the client legal services, that raises such a strong presumption that no amount of distinctiveness can cure that confusion in the putative client's mind. Is that kind of what we're talking about?
Even if it's a sophisticated client
All I would
advised
say
by
is
a lawyer.
I'm not trying to say it could never happen. I'm not trying to
Okay.
take that position. I don't know that we're the appropriate venue
Okay.
But why?
to make that, because that's,
We're not saying what would happen, we're saying what the analysis would be. Because we certainly don't.
but aren't we concluding, and therefore the rules of professional conduct and, professional obligation of the lawyer would not apply?
We're
Because you're
saying-
able to disclaim
We're
that,
saying,
even to a current client.
just let me know when you're done.
I just
so
don't
can
have,
respond.
we just don't have the authority to support that position. At least not in this opinion as it stands.
We have, what,
In a separate matter? A separate business in a separate matter? What authority do we have that you can't?
None,
so what, so
So
what's the,
so what's the problem?
because we don't make law.
What do you mean we do? We step into areas, the main criterion for our stepping in is that the law is unclear. We don't step in where the law is obvious. What's the point of an opinion about where the law is obvious?
I mean, obviously we'll just have a difference of opinion.
Well, my feeling is I think you're entitled to that
I mean,
view.
we have the Supreme Court.
My view is let's get it out there. Let's see whether people hate it or love it. And why they hate it or love it.
I mean, the fact that it's not useful, if you want to say we've got the Supreme Court's opinion from 1933, we've got an industry that almost 100 years later is totally different, it's not economical for certain firms to even survive unless they can do different things. So it's not enough to say, oh, we've got an opinion from 100 years ago from the Supreme Court. They're so, the Supreme Court we hold them in such reverence that no one is ever going to talk again about what's possible. I mean, that doesn't seem all that helpful. Particularly, I mean, certainly you're right, that if the Supreme Court said the opposite of what we're saying, then you're right, we're done. But that's not the case. What we have is sort of an absence of clear authority.
I have to say, maybe I'm just totally dumb here, but this is an approach that's persuaded something like 38 states, right? It's not like we're doing something totally loony.
Talking about respect with 5.7?
Yeah.
When we did the math in 2016, it was 26 jurisdictions. Not that it matters, but.
Right, okay, but a good number.
I looked up the memo before the meeting, I just saw. That's fine, I'm not a voting member, I mean.
Well, I
just
think any more comments, folks?
Just one, Steve. I was just noticing, maybe if you address the 1.8.1 business transaction for client kind of issue, it would allow certain business transactions subject to informed written consent, and maybe that's where you're going with it. Because if it's a current client,
Well, I think, no, I don't think it actually is, the standard for 1.8.1 isn't whether, I mean, what we say, and this is partially responsive to what Andrew says, is that if you come in the door at a lawyer's non-law business because because your lawyer told you it was a good place to go, right? That's the place to go, we think 300 applies. Because that's a situation where you're there by reason of the lawyer-client relationship, or where their recommendation might influence how you deal with them. And so that we are interested in the relevance of current client, right? We're just saying that, but the 300 would apply because the lawyer sent you.
I just had one more suggestion that, I think maybe we need to talk about this internally a little bit more, since we've got so much going on. And the only reason I suggested this, if it were released from this committee in some publication, I don't know if you're talking about formal comment, comment period, but when we send something out, it kind of indicates a presumption that at least we've come to consensus about it for the purposes of the public. And maybe we should get closer to that consensus before we think about inviting input from the public or from the rest of the membership.
Wait. So first of all, is it your view that you want to go back and do some more revising based on this comments, or that you think that?
I think I'd love some guidance. I think that, I mean, look, I think if the sense of the committee, and I'm worried that we have a lot of people who are missing.
Yeah.
So but if the sense of the committee were that this approach, I think the biggest question, frankly, is whether we want to take on the fiduciary situation. That is to say, assuming we can define it appropriately, so maybe I'll make it a real estate broker in the next version, right? Do we want to take the view that a real estate broker who is a lawyer, right, can practice as a real estate broker without, if we want to do that, that seems to me the big hang-up right now. That's what the issue that Andrew has raised. If we think that's worth pursuing, then I'll do another draft with that in mind. If people think that's too risky or too far out there, that's important to know, because I don't think it's to my mind, it's the most interesting, and it's a good productive part of the opinion, but if people are worried or don't think they could get behind it, that's a different question.
So do people want to make brief comments on that question?
Yeah, I just, I think this is a very interesting discussion, and I think you've put a lot of good work into a lot of really good analysis. And I would, not to put more work on your plate, but I would like to see if we're able to refine it a little bit more, like we've talked about in the discussions, how that would look related to the opinion. And I do have a couple more comments, but you wanted to address specifically.
Yeah, I think what's the question Steve is putting out there is kind of like, do we want to fish or cut bait on this fiduciary portion so that he's not continuing later on it and then just come back afterwards? I don't know. So if people if you feel like they don't know yet, that's fine. But to the extent that people have views, it is true that we all feel but to the extent people are here, have views, speak up.
I like the idea of possibly looking at it as a real estate agent broker situation, because we all know that's reality, right? It'll be a good example that everyone can relate to and understand, and if we can clean it up.
It's a good one because it's a good one, Dina. Kendra. It's a good one because, in fact, one of our earlier opinions takes the other view in the non-distinct
Right.
same transaction situation, so it's a nice way to pivot off an opinion in the way
Yeah,
that
that's a good
you
idea.
suggested.
Yeah, so I'd like to see how that fleshes out. I don't have the same concerns necessarily as Andrew, although I see his point. But I think it's a valuable part of the opinion, and to the extent we can massage it a little bit to get the group to agree, I'd like to see if we can make that happen before we decide to completely cut it.
If we're doing the real estate broker portion, I have slight concerns on that because you can act as a broker with your law license. You can be exempt from real estate broker requirements and licensing requirements as an attorney. And then you can also be exempt if you actually want to get your license from taking the courses in order to obtain your broker's license. So they're very intertwined. So in order to be a broker, you have to do all your educational requirements, right? But if you're an attorney, all of those are waived and you can just be a broker.
And then
Or-
you get to waive the professional rules too.
Yeah,
Right. Or you can be an attorney and act as a broker if you're representing a client. So you can go, like I could go do a residential real estate case. There's like there's splitting commission rules and ways you have to get around it. But those two are, the business suppression codes for real estate brokers have exemptions for lawyers to get in, which.
Yeah, do you have to think, and so when you do that,
Yeah, maybe not
right?
We got a fallback.
Suppose you do that with a can you share your fees?
So that's what I was just looking at. If you are,
That's the question.
if you are a non-broker acting as a real estate broker for all intents and purposes with a broker on the other side, I think the way they get around it is you charge half the commission and then you charge your own client the other half of the commission and they pay you fees. In other words, like a normal, let's call it 6% commission, the seller always pays that commission, right?
Not
So
always,
if
but
you're,
yeah.
well, usually the seller pays it and then the seller's broker pays the buying broker. If you were to do it as an attorney, I think the way you get
I don't
around
have
that.
any problem with holding the lawyer in that situation to professional standards. That's confused as you can get, right? It doesn't fit at all with my sense of what we're trying to talk about.
Yeah, I think that makes it not such a great idea.
It does.
Switch it to real estate. I personally, I mean, I don't know, I don't really have a great understanding of what a professional fiduciary is.
Well-
When I read it, I just thought, okay, this is a generic fact for someone who's acting in some fiduciary capacity. And the point we're trying to make is that you can act in fiduciary capacity as a law-related business, and you could disclaim.
There's a whole
How about
California
a
professional
conservatorship?
fiduciaries website.
Would a
There's a-
conservatorship service capture the same thing?
Yeah, well, I might be able to explain professional fiduciaries in a way which makes sense.
Yeah.
And I have an example of a situation where a lawyer who's a professional fiduciary and just functioning as such might not want to be subject to the professional rules, which is, think about California in the absence of Model Rule 1.14, or indeed of any sensible way to deal under the confidentiality rules with problems of where your client is being exploited, right? A professional fiduciary might well think, I don't want to be subject to the California confidentiality rules. No right to make an implied right to make a disclosure to protect my client's interest, right? I want to be in a more sensible realm, assuming that the professional fiduciary realm is that sensible realm, right? That's at least something.
Maybe just picking a concrete example under that professional fiduciary umbrella
Yeah.
might be a little easier to swallow and understand.
That's exactly
Yeah.
right, and Randy
So-
and Randy makes the same point in his comments too.
Yeah.
He says, "Show me why it would matter to somebody."
Right.
I think a lot.
And I think that's a really good point.
I think a lot of trust and estate firms will act as professional fiduciaries and not lawyers in that context, right? Because a trust needs a trustee, and oftentimes, if it's not a family member or whatever, it's a professional trustee. It's either a bank or law firms will do it.
right?
Right, but you almost never would have a situation where a law firm also acts as a trustee and they can disclaim,
Well,
right?
yeah.
Right, and I think that's the current client comment, like, that's a perfect example, and there's probably a lot of other ones where we could say there's absolutely no way you could disclaim.
Yeah.
Your hypothetical, Steve, you can see that as, this sort of arm's length business transaction. Here's the business across the street. You're a sophisticated client where you could arguably say, why shouldn't they be able to disclaim? And maybe some examples about those would be helpful to some of these situations. I don't know, maybe that's, but I think in a lot of situations with the current client, other than the example that you provided, I think there'd be many situations in which you really couldn't, where it wouldn't be fair to think that they could disclaim it because there's just too much confusion.
I couldn't agree more, and I think one of the things that comes out of of all the comments about the current former client situations is that that's an important factor.
Yeah.
A very important factor in thinking about whether these consent regimes could work. For an unsophisticated client, the fact that somebody is or has been your lawyer sets a very steep bar to an effective disclaimer.
So I think right now, if I understand it, there's a request that you slightly change the fact for scenario one.
Right.
To a more concrete version of fiduciary.
Right.
There's Justin's comment about
Textualism.
parsing language.
Textualism.
Right.
Yeah, I'm going to work that one a lot.
Can I just make one more comment? And it's at the very end of that paragraph that you've been tinkering with a lot.
Yeah.
And it's just that language, the last part of that sentence, which just says, there doesn't appear to be any good reason why a lawyer who has the separate non-legal business should be required to comply with rules that are unique to the legal profession. I feel like that's too overbroad and fraught with peril, that sentence, because obviously you talk later about, well, 6106 doesn't apply and this doesn't apply, but I was wondering if there's just a different way to say that.
All right, I think I can do that. Different way to say last sentence.
Oh, okay.
Play with it.
Yeah.
I mean, you could just say comply with all the rules.
Yeah, exactly. That's, I think, what.
I think Dee is trying to capture the fact that there are certain rules that you are.
Yeah, like not lying and stealing.
Right.
So I agree, just to, I think that highlights the current client point, and Randy added a comment, I don't know if you saw it in the version he says, but to that point, he says the good reason would be the prophylactic concept that if a client in a separate matter from the non-legal service matter is receiving a fiduciary non-legal service, then the nature of the fidelity and loyalty owed by a fiduciary is so indistinguishable from a lawyer's similar duties that the rules must apply. And whether or not we agree or disagree with that, I don't know. Again, just going back to my earlier point, I want to rehash, but the lack of authority that allows the disclaiming of that in the current client situation just makes me personally very uncomfortable. But the fiduciary relationship at arm's length, as Dina says, I'm less uncomfortable and I'd be willing to see it.
I
So it's
hear
the
you,
current
and
client that I'm
I've
very
wondered
concerned
about that over time. Is one question is if some people's instinct is fiduciary, right? So what? If the lawyer's a fiduciary, right, and they change hats and move across the street and become a different kind of fiduciary, what's the big deal? They might as well just keep doing what they do. It's not that big a difference, right? It's not that big an imposition. So I need to find something juicy where a lawyer acting as a lawyer needs to do something, but a lawyer acting as a fiduciary could reasonably want to do something else.
Well,
And their clients could reasonably want to do
haven't
something
we
else.
thrown out a bunch of those, like IOLTA, and, I mean, the question is, do you have the whole, panoply
Right.
of lawyer rules applying? I mean, when I read Randy's comment, my reaction was, it sort of answers itself, which is, it's not like the client, the consumer is without protection, because a fiduciary owes a lot of duties. So, the fact that all the California rules of professional conduct don't apply does not mean that the lawyer who's acting in the fiduciary capacity is like free to run hog wild over the client's interests.
Sure, and I understand that, and going to my point about just being uncomfortable with like setting that as the policy and an ethics opinion, notwithstanding the fact that it's non-binding, is like, this is such an important issue, and we've talked about this with respect to other ethics opinions. It's one of those things I feel is best left to being litigated. It's going to be fact-specific. To have this broad statement, perhaps, where we say the lawyer can disclaim the application of the rules of professional conduct, that just doesn't, seems like
But
best
how
left
about
for
when
a
it's
court,
litigated?
and particularly the Supreme Court.
The thing is, the interesting thing that springs up is like,
And I'm not saying that you guys aren't right. I'm just saying, I'm not sure we're the best place to litigate it.
right, well, the interesting thought that I have about that is that we often only get, particularly in discipline decisions, the worst of the worst, right? And so then you get the law as it kind of is formulated in context of some worst. And we're trying to give some guidance to people who want to do it right. And so in a way, there's no other forum where,
Sure.
so that's just the flip side of what you're saying.
And that's fair, and if that's the case, if we just, and not to like be overbearing within the opinion, but if we were just more clear about that, the client is protected, notwithstanding the fact that the lawyer's disclaiming the applicability of the rules of professional conduct, because in this circumstance, these other rules of a fiduciary are going to apply in our hypothetical. I would feel a little more.
I think that's a good point.
Yep.
That
But
to
that's-
state that, so that it's more clear.
And it's gonna be beneficial to Amy's point to the client too, to know that like, okay, remember, when you say something, this to me, it's not covered by attorney-client privilege, and just having that information is also really important and will protect the client, because it may turn out that like some other court or something decides that was not an attorney-client relationship and that is not subject to privilege, and they may be, so it could be more beneficial ultimately to the client in understanding that, right? And so I think that's beneficial.
So.
Yeah, I think that, what I hear, can I rephrase that, because it's a very good point.
Well, I
know, I think I heard it.
Yeah, okay.
What I think you're really saying is that in these vague areas, where somebody might say it's legal services for one purpose, right, and not legal services for another purpose, that there's value for the client in knowing which it is.
Correct.
Yeah, we might put that point in here.
Yeah.
Because that's true.
Yeah.
Right.
And as Dina says, sometimes it's gonna end up being out of your control when a court comes in and says, privileged, not privileged.
Yeah.
And you would rather know it from your lawyer than later from court. Or what?
I said, or your non-lawyer lawyer.
Right. Yes. Other input? So it seems to me, if I'm reading the room right, that there's still, that mostly people are generally on board with what what you and we've been attempting to do in this opinion, Steve. So.
All right, well,
it seems like we're
nobody's
wrapped at
bound,
it.
nobody's bound, but I'll take that as a sign that I should revise, and I will.
That doesn't seem, I wouldn't think extensively either. I mean,
No,
think
no,
just these
I-
couple of areas.
Well, I hear, I think there are some very good points have been made. And that the next version will be stronger. Whether it'll be strong enough, who knows, but it will be stronger.
Cool. All right.
Amy, will
Yes.
this be on the next meeting's agenda?
It will. Yeah, you're making a good point with Mimi, which is if we keep putting everything that we have talked about on the next, that the folks are already talking about, never going to be gotten to, but I don't know how to deal with that. But yes, we'll talk about this one next week.
I have to go to a phone call.
Okay.
Be back in a
Perfect time.
All right, so subject to Andrew and Mimi's perspective, what I was going to propose to do next is lost or stolen laptop so that we can get it done before Richard has to take off.
Okay.
And then after that, we will talk about symposium topics.
Great.
Okay, so let's go to Richard's, which is it must be in one of the editions that we got.
Yes.
Yeah, this was mailed out on Monday.
So much good stuff.
Right. Yep. All right, so so, all right, Gina, me, Steve. All right, Richard, do you wanna, talk about, to give the committee an orientation about what you've done or what you're interested in hearing,
I
getting
would
feedback
very
on?
much like to, because I would like to the extent possible, focus your comments. First, it's obvious the title, the digest need to be rewritten. To the extent you guys like the hypotheticals that we've come up with, and they stay, then we need to have the title and the digest reflect that, so that's a given. So that's the first thing, is do the hypotheticals adequately capture the major cyber risks lawyers face? Do we want to subtract any or add any? We can go on and on. I thought 5 did it. I do have to clarify with respect to lawyer E, who works at the public Wi-Fi spot. I finally confirmed with my computer science major sophomore grandson, who finally got back to me and helped me understand what actually goes on. And it really is keystroke tracking software that can actually, the hacker can actually see the strokes on his or her machine. That's all they can see. They can't go behind that and get into your old email archive. So I have to rewrite it to mean he's typing an email to a colleague or a public relations person or something where he's announcing this new Alzheimer's cure drug, and they're collaborating on how the announcement's going to go. And that's how the hacker puts together the name of the company with this unbelievable breakthrough. But there's questions about that, for example, and I know nothing about insider trading. So how does the lawyer find out about it? Which would trigger a duty to disclose, possibly. So I don't know that. So we have to figure that out if we're going to keep that hypothetical. As you can see, I incorporated the ABA, the new opinion of last year, 483, into the opinion. I think it's a very good opinion, and I like the analysis. So do we agree with that analysis, which is basically a factors approach? They look at what lawyers, the fundamental duty lawyers have is to engage in what they call a process of evaluating their cyber risks, as opposed to taking specific precautionary measures as a checklist. I think that's a much better approach, so I've adopted that, but of course we need to address that. Do you agree with the analysis of each particular hypothetical? I put in 2 for law firm D, 2 alternatives: disclose, you don't have to disclose, with conditions on each. So how do you think we should come out on that? Let me just start with that. I have other questions. There's some footnotes that need work. I have questions about whether to flesh them out, but let's open it up and get some thoughts and then go from there. Is that okay?
Yeah. Okay, so we don't need to like worry about who's on the side and who's not. Let's just, if people have comments, just jump in there.
Preferably on the red one, if you have specifics.
I guess I'll start with a couple. I mean, I guess with respect to the E, the one in the cafe.
Yeah.
I guess I feel like it seems a little bit exotic and implausible to me. I don't want to say implausible because probably all these things are plausible.
Oh, they're real. They're not just
Well,
plausible.
I don't mean that keystroke hacking doesn't exist.
No,
but
this actually happened. He got inside information.
This is based on a real
Yeah.
fact pattern.
Yeah.
Someone
It was
got.
newsy. I don't know how true it is, but it was a news item I came across on some security, or some guy wrote an article and talked about it. So
About this with a lawyer.
that's a good question.
I guess
No, I don't know if
the point I was just going to make is I think it would be helpful to me to know what the ethical issues are with using public Wi-Fi. Period. I mean, like this is much more exotic. This is like you think you're using public Wi-Fi, but you're actually on some hackers separate thing. But like, I mean, just if you're using an unsecure server or network alone, is that, are there problems with that? Or maybe people think that's so old hat.
Problems with it alone, but there are risks that someone could then
You bet.
access your information.
If
So
if it's
using it-
unencrypted
yeah.
and so
Well,
forth.
but if there are risks, then is that, depending on what kind of work you're doing. But if you are emailing your client about something very highly sensitive on a public network, that's already a breach of 1.6, right? Or it's a risk of a breach of 1.6.
Well, there's a risk, yeah.
It's not a, okay. So I guess my thought was like, do we need something as exotic as that, or do we just want to tell people about,
Well, the problem is if you don't have a specific set of circumstances where there's actually been a breach, then you don't get to the duty to, there's nothing to disclose, you've just done it. And then it becomes just a best practices piece. And I've tried to stay away from best practices.
okay.
I tried to focus it
So
on the
each of
duty.
these you want to be actual breaches so we can get into the duty to disclose?
That's the assumption I've been making, we can change that.
Well, I guess I didn't get that because there's the first, we do talk about the duty to disclose. I agree that's a significant part of the opinion, but before that, we talk a lot about competence and duty of confidentiality. And it seems like those, it does not seem competent, it does not seem consistent with your duty of competence to me to to discuss highly confidential client information on a public Wi-Fi network, for example. I don't think you need to wait until there's a breach to have breached your ethical duties. So I guess the one question is this purely an opinion about disclosure, which could be really useful on its
Well,
own?
it could be both. No, I don't think they're exclusive.
All right,
No, I think
Okay.
that's a good point you're raising.
okay.
So you're suggesting then expand, when we talk about that lawyer, E, in the confidentiality part, do I say?
I don't think I'm saying expand, and I think actually this is there's a lot we're already taking on, I wouldn't want to see you expand. I guess, in a
Well,
way,
I'd say,
if,
look at line 285. Starting on line 285, I talk about this lawyer. Lawyers who keep confidential information on their portable devices ought to be aware that accessing public Wi-Fi may, et cetera, This is illustrated by E's exposing confidential information to anyone with the capability of eavesdropping, electronically eavesdropping. Attorneys who work on client matters remotely must take reasonable precautions. I can expand on that if you want, but that's.
well, I suppose, that seems fine. I guess if I was reading this, I'm like, you've got this whole elaborate thing about it being hacked, but I'm not sure it needs to be hacked for someone to get into it.
So it could, yeah, certainly it can say here, quite apart from the hacking.
I guess my feeling is that maybe 5 scenarios is more than we need. But I'd be interested in other people's thoughts on that. It just seems like a lot.
I'll raise that with the drafting committee. We will have a conference before the next meeting.
And I also wonder, I have a personal preference for very, very simple hypos. Gina, yours to me is a model of simplicity. Because I don't know that we need that much. Like for me, this is my personal opinion, I think A could be a lawyer's laptop is stolen.
Yeah.
B could be a lawyer briefly loses her briefcase and then gets it back.
Right.
So like we don't need all this detail because it just clogs up my brain when I'm then trying to follow this long analysis, So for me, like that would be, and maybe then I wouldn't feel like we had too many hypos. Maybe 5 is fine as long as they're like 2 sentences long because we just need to get to the core, right?
And in the discussion section along that lines, it's like you could say related to like the briefcase, if the attorney recovers it and feels really reasonably confident that nothing was taken and it was in the exact same situation, then that would inform their decision about disclosure and things like that, right? That the more details could be a little bit when you're discussing the application of the rules, you know?
Yeah, right, that's true too.
Sorry.
All right.
Yeah, I would really love to see it, like the sort of fact stuff pared down. And then I would also, I felt this way for a long time, I just don't think we need to get into whether these things could subject an attorney to professional discipline. I just don't feel like that's our,
Yeah, there's one paragraph on
it's at the,
that.
it's lines 291 to 305.
Yeah. Others agree?
Yes.
Any others? Say yes.
Right, just draw conclusions as to what the obligations are in each situation and let others decide as to why.
So to read that paragraph. Okay.
I'm kind of perusing again, but if other people have stuff to say, speak up.
Jump in.
On line 322, it says ascertainable extend.
322?
322.
I don't see that.
Oh, I guess it's on the clean, sorry.
Can you relate it to the red line? I have the clean here. Can you tell me the page number or the line
Are you
number?
talking about the paragraph before the conclusion?
Yeah, 394 on the.
Yep.
Or reasonably ascertainable extent to which.
So you must advise of the known or reasonably, extent.
Yeah, instead of extent.
Yes.
And then the one thing that I notice is not in here is reference to insurance. Because if they have a policy that covers this type of thing, one of the things that we might want to mention, obviously, every policy is different, some might have coverage, some might not, but we should advise them that one of the first things they should do is check with their insurer.
That was in a footnote in a previous edition.
Right.
I should leave it in.
I liked that, yeah. I think you should leave it in because that's extremely important. And then there might be under that policy or under the insurer's requirements, additional steps that they have to take.
Right.
In order to meet the terms under the insurance and to get their coverage, so. And I almost would have it be in the body instead of a footnote, and it can just be a simple sentence to say.
I'll put it back in a footnote, then we can discuss if it's substantive enough to put it back. Yeah, I think that was inadvertently left out because it was attached to some text that I removed, and so is there any dissent with that? There was I think someone mentioned that maybe we don't have to mention insurance, but I thought it was a good idea. Did anybody else?
My recall is that we massaged the language and liked the idea of signaling that you should
Right.
consider the issue, right?
All right, so it'll go back in at least as a footnote, and then we can massage that.
I wonder if this is a good opinion.
Oh, wait, I'm sorry, let me just, look at footnote 12. Sorry, I'm wrong. If you look at footnote 12, second sentence. It's with respect to attorney A. Maybe we should get, not just A.
Oh, you said, okay.
That's the footnote. So
12?
footnote 12 on page 10 of the red line.
Notifying malpractice carriers.
Because the carrier may have to take critical initial steps, etc.
Affected clients. Oh, no, then attorney, it's confusing because it's talking about two totally different subjects in the same footnote.
Yes,
We might want to put them in two separate.
separate them out.
Yeah.
That's good.
Or move it. Is that attached to?
You know, I sort of wonder, Richard, whether this isn't a good opinion for a discussion of management policies, which we have now. We have the new Rule 5.1.
Yeah, that's what I was gonna say.
And this is all about like how a law firm sets up, you know, its rules about how the lawyers are to, you know, and the staff is to function. And
That's
so
consistent.
I wonder if we shouldn't have a separate section saying, like, you know, all of these things flow back to what the policies of the law firm are. You know, can the policies about whether you can keep things on your local hard drive or it has to be on a server or in the cloud, policies about what you are not allowed to take out of the office, policies about what's, you know, guidance for staff, all these things
Right.
relate to. And now it's disciplinable for management not to have those policies.
I think that's what last time both Eric and I raised that issue about 5.1 and 5.3. I think
It's in a
I
footnote.
left it in a
and it's in a
footnote.
footnote, yeah, and I think I was gonna say make the same comment, which it either I think needs to be in part of that competency discussion, more directly saying like these
Yeah.
duties extend in this context, or it's a separate thing, because I think that's a big part of this, which is like, and I don't think it really can be ignored or shouldn't be in this context, you know, be much more front and center, that concept. I mean, you know, you have good analysis on the other stuff, it just needs to go with that, I agree with that.
So it really should go in the text then,
I
because it
think
really
so.
is a
I think
critical part.
Yeah, I think
Yes.
so.
5.1.
Yeah.
Yeah, 5.1 and 5.3.
Yeah.
Yeah, so I think that's a good idea. We'll do that.
I mean, I think it's actually more central than competence
Well, it
because,
ties in with the ABA opinion. It's just that firms and lawyers have to have a process of evaluating
Yeah.
their risk, which is exactly what this reflects.
right. That would help a lot.
Very good.
Because I think the disclosure stuff is super interesting and law firms and lawyers do need some help in evaluating when they have a disclosure obligation, but I also think, you know, just, you know, the other piece of it is the before the disclosure, before the breach happens is also still something of.
Critical.
Yeah.
So yeah, just for the record, since we're moving that into the body, I am gonna say, I think we should move a sentence regarding insurance. And I know you don't use the word insurance there, but move that into the body. Because here in this footnote, it's specifically referencing attorney A, and
Yeah,
I just think it's more applicable to the entire situation of contact your insurance carrier to see if there are additional obligations and if you have coverage. Something simple.
all right. Well, I'll think about how to. what to do. That's it?
That's already a lot.
Oh, it's,
I guess I feel like it's not a super long opinion, but I still feel like we go on about competency, a competence maybe more than we even need. I mean, you know, I'm not sure that you need that very, very long quote, lines 178 to 189. I mean, are we just, yeah, of course, lawyers need to take, you know, precautionary steps. And I mean, I'm not sure you need to quote the whole thing about how you should use secure mail and all that stuff.
all right.
Yeah, and I agree with Amy's comment about trying to make the hypotheticals more simple.
Shorter and simpler. Yeah, I can do that. I can do that. All right.
meeting in the 483, that was good, and I think that,
Yeah.
really beefed up that part well with that
Yeah, it's a good
opinion, yeah.
Thank you then.
Great,
Very good.
okay, cool. All right. Let's look at the symposium topics. Did anyone have a chance to look at the revisions to 12.003? We're sitting over on the table over the break.
I did.
Well, we're not going to that yet, but I'm just curious. All right, well, we can look at that later. So symposium topics are at the back of the, aren't they at the back of, yes, they're at the back of our packet. Where are the ones, oh, here's the MFA ones. All right, well, let's put the MFA, so let's assume that we're gonna have one topic that's on fee arbitration, but not talk about that yet, and just talk about the 3 other ones that we wanna have.
Ethics update.
Ethics update. Do we always do that? I just can't remember.
It's that, it used to
We
be
used
an
to do-
annual meeting.
right.
Because, but people, it was like the most popular program.
Yeah.
At the annual meeting, and it might be worth to do one because the rules are now in effect, and two, I don't know, because nobody does it anymore.
I love doing it. I mean, it's
I
super
thought it was
fun.
the most interesting, I mean, all the panels were interesting last year, but I thought people looked forward to and enjoyed the discussion of the cases. And it's just kind of fun. It
Yeah.
goes beyond just rule point 1.x says this, that, and the other. You talk about cases and there's flavor.
Weird.
For me, I mean, that's a must.
Yeah.
That's
And
my
you can talk about a lot of different things in one panel. It's-
Yeah.
Yeah. Okay, well, that's easy then. All right, we got one, guys. Okay,
So it's definitely gonna be a panel?
I think so. I mean, we haven't voted, but
Okay.
anyway, it's definitely on our list.
Okay, on the list, okay.
Should we have a panel perhaps on the task force on access to technology? They're only going to be about halfway through their work, but all their work is public. And so we definitely start talking about the kinds of things that they're speaking about in terms of being barriers to access to justice.
Is this a different committee than the access to?
That's the same.
Same one.
Yeah, and then Dina actually suggested maybe that same thing, but more maybe focused on unauthorized practice of law, access to justice, including some of the ADL stuff, and maybe even multi-jurisdictional and multidisciplinary practices. But we can, it's just more of the topic than.
Yeah, I'm
Just
just,
to
like
be
that.
more refined, but like just that concept that
Right.
that task force is, looking at those issues that I think are interesting. The ABA is looking at that or has looked at that and is going to issue opinion on the UPL revising those standards. I think it's a big issue in a lot of different contexts, whether it's access to justice or people being, sort of able to practice law from anywhere and what that means and where you can practice. And I think those are like kind of cutting edge issues that would be interesting to explore. And, even getting someone from maybe the state bar disciplinary, you suggested that, like talking about what kind of UPL stuff they do get, like what do they look at, like from that perspective. I mean, it would just be, that could be some, there's a lot of interesting parts of that we could look at.
I like that. Actually, I like your formulation, Dina, because one of the things I'm hoping to stimulate, I would want to stimulate through that panel, is when the task force does come up with its work product, which is going to be at the end of 2019, it would be nice for people already to have some thoughts about that.
Yeah.
And be able to respond and maybe do some input. And the fact that the seminar is going to come up when they're still in the middle of their work is, I think it's going to help that train of thought rather than people get cold with some of these concepts.
Very topical at the moment with.
There's a move afoot on the national level to kind of revisit the rules for division fees with non-lawyers.
Mm-hmm.
And I think many people have cast us as an access to
justice issue in terms of those rules being unduly restrictive in terms of lawyer referral services. I don't know if that's putting too many
No, I don't think
topics
so.
in one
I think that's,
basket, but I think that fits well.
Ken just making a face.
Yeah.
What's your
I
face
think
about?
those are kind of two separate topics that are
Really?
both pretty meaty. I'm
Yeah.
not sure. They're related, no doubt, but I'm not sure you
Turn
can.
on your mics if you're gonna just keep on having a discussion, just because I don't know if they're getting it on web
Right.
streaming.
Right. Our
Sorry,
public-
sorry to
our
interrupt.
public is
They are both very interesting topics. They could be married together, but I don't know whether you would get the benefit of the discussion trying to cram it all into one panel. So like when I think of multi-jurisdictional practice and even unauthorized practice of law, it's more attorneys who are licensed in various states and are, you know, working out of their vacation home in the summer or trying to move within their firm to different offices and things like that, versus the non-lawyer component of sharing attorney's fees and referral fees and stuff like that. So, they do relate, but I think there's enough in each topic to be their own panel. So do we want to cram it all in as the?
Yeah, the memorandum that I haven't looked at it before today, but the memorandum for that task force's charge is very interesting because it starts out with the proposition, what if there were no rules at all? And we were building this from the ground up. And they go on to talk about things like limited license legal technicians, which is kind of like a UPL issue. And access to justice, as well as, you know, the whole topic of to what extent are the rules we have now anti-competitive. So anti-competitive that we are strangling access to justice, and I don't know if that's a
So I'm actually on that
starting
task
point.
force.
Oh, you are? Well, you know it better than I do.
Through April, yeah. Working on those
Yeah.
referral fees and
Oh,
fee share
yeah,
rules.
okay.
And the focus there is more on the non-lawyer component of it. So you're
Right.
right, non-lawyers can definitely be practicing law unauthorized. But I think the multi-jurisdictional practice is more like an attorney practicing law in a state where they're
Right.
not authorized.
right, I mean.
Well, that's a huge issue.
So,
So, okay, just to sort of tell me, people who have a concept of it, say it was just a multi-jurisdictional panel. Who are the type of people who would talk and what would they be talking about?
I think the new commission that was put together, what's it called?
That task force.
The Access Through Innovation of Legal Services Task Force.
And that's one of their areas is MGP?
It's, you know,
I think having someone from that task force on the panel would be interesting because it could also inform everyone that, hey, this panel's been formed, this is what we're looking at. And then maybe somebody from the state bar who deals with UPL and discipline from the perspective of attorneys from other jurisdictions that are coming into California. You know, do they see that? Scenarios that come up maybe just to give it a more realistic perspective. And then talking about the ethics rules that are currently in place.
What they seem to see more from a discipline standpoint are California attorneys who are seeking to market in other states, which is, you know, kind of the flip side of the same issue.
yeah,
I
because
agree.
they wouldn't
It's the
have
same
authority
thing.
to discipline an attorney technically that's not licensed in their jurisdiction in the first place, right? And so it would be a matter of what do they do? Do they then refer to the jurisdiction where that attorney's
Well-
licensed, or how do they handle that?
They do.
They just have some enforcement authority by way of an injunction or a superior court order. I mean, what they used to do, and I think they're still doing it, I remember doing it in the 90s, going to superior court, getting basically an order assuming jurisdiction over the non-attorney's practice. Not non-practice by attorneys, but non-practice by non-lawyers. And the state bar will show up, you know, get that order from the superior court, show up one day and take everything away. You know, the files, the computers, access to the bank accounts.
I think there's also something in the rules that, or maybe it's the state bar rules that say if you're coming into California practicing law, then you avail yourself to our rules and jurisdiction. So
That's
there
in
is
the-
some way that they can prosecute UPL that way too for out-of-state lawyers.
Well, in terms of the remedy, I mean, the safe harbor provisions in the California Rule of Court.
Right.
Rules of court say if you if you qualify under one of those safe harbors, then you subject yourself to the disciplinary jurisdiction of the state
Right.
bar. So conceivably, I guess the bar could issue an order
And the non
suspending you from practice or taking away your safe harbor.
right, and the non-transactional component of that, on that list, is
Yeah.
one that you don't have to report, you don't have to get permission from the state bar to come in as a transactional lawyer. So that's one that people abuse a lot because they don't actually have to notify the bar they're here, but yet can try to say that they fit under that exception, whether they do or don't. But I think that's something the state bar has handled, and that happens quite often.
Yes.
Let me just mention, for the actual symposium event, they will only event next week and once in February.
Right, so that's it.
So I don't know how far along their work will be by then, just so you know. I mean, you guys are free to have a discussion about the issues and stuff, but I don't know how much you can rely on any recommendations coming forward by then, because I don't
No,
think.
I wasn't even thinking recommendations, just notifying everyone that this commission has been formed, and this is what we're gonna be looking at, and this is definitely an issue that's evolving in the practice of law now that technology has made it so easy to move, between states.
So, I want to move on to a couple of discussions, a couple of the others, and also find out, do we need to make our decisions on topics today? Because we just have half our committees here.
Yes.
Yes, we do?
Yeah.
Okay.
Couldn't circulate a list to people for a email poll even?
No, because that's
No, you
considered
gotta
a
be
meeting.
noticed. Bag the keen, baby.
Baby.
All right.
We could notice a column. We could notice a conference call.
Well, let's see how we're going. I mean, I feel bad because it's a lot of people are missing it. Well, maybe can you move the box? So what we were talking about, so first we said we'll probably do the ethics update. Steve, you should know that because we'll be on that panel. And then we jumped into talking about the unauthorized practice of law topic with a bunch of things underneath it. And I'm trying to get, I just don't quite, I'm having trouble conceiving of what the panel would be and what they would talk about, especially if the focus was on MJP. Like, I don't know if a state bar person, like from someone from the Office of Trial Counsel or who, I mean, I don't know that they're certainly not going to be people who are saying, like, here are the flexible ways we might be able to approach this. Like,
They're going to be saying just the opposite.
Yeah, they're gonna be giving you the real life examples
horror
of
story.
who has been, who gets in trouble for UPL.
Right, but I mean, I guess to me that's in quite a bit of tension with saying like, basically they're going to be talking about the current regime, which is incredibly restrictive.
Right.
And I mean, I guess that could be useful, but it didn't. I'm just trying to imagine that. I would think that those people would be the least comfortable with all of this conversation about.
Yeah, I guess the point is to show, okay, they're having to enforce these rules that are so antiquated and haven't kept up with technology and the ever-expanding law firm, right? And then there's this commission that's going to come in and look at these rules that are currently being enforced to see if there's any way, you can make it more flexible for that type of a practice to occur. I don't know.
Are they just going to be a punching bag?
No,
They're going to stand up and make their arguments for why the guild should continue.
Yeah.
Right.
As it always has, and forever and ever.
And
Protection of the public.
is it going to be okay?
I don't know. I don't envision that it'll be a one side versus another. I more envision it's just like laying the landscape. Here's what's happening now. Here's what this commission is hoping to do or look at, and then maybe it'll move here in the future.
And what other, like ABA and nationally, what the movement is and what are the issues they're concerned with and what they're trying to, what changes that the consensus that they have is in terms of their studies trying to move forward in this area, whether California would be amenable to that, whether.
So this is why I sort of lit off at the idea of combining the MJP discussion with the fee sharing. It's sort of like there's a lot of ways that.
I mean, you definitely could.
I mean, I just think, just thinking more kind of broadly about like, hey, what are all the different ways the profession could be modified in order, and what are all the current ways the profession is so, so many restrictions, so.
Well, another way to do it would be, and maybe this is just obvious, would be to have a symposium that gets a piece that brings in the people from the new commission. Maybe that's what you were saying, I just was outside the
But
door.
Mimi pointed out, they're only gonna have met twice before
I don't
that.
think that matters if
Yeah.
they're the right people, right?
How
If they're,
many
if they're, if they're, if they're the sort of ideal people on that
Per
commission,
committee?
it could be really
Um,
interesting.
It depends on which committee you're looking at, because there's an AI UPL committee, which is one committee. And then they have an MDP ABS, which is Alternative Business Structures Multidisciplinary Practice Committee, and that's another. So then it's about 6.
Isn't there also a committee or commission on actually the fee sharing referral rules as well? Or non-lawyer services or something? There's a subcommittee on that? Yeah.
It just might be really fun to, suppose you got one person from each of those subcommittees, right? To just talk about what's sort of on that, what's coming up.
Right, that's
What's
what I
on the
think.
agenda, what's fun, what are people thinking about? And what are the, just not so much no decisions, just where it is and where we're going and so
Yes,
forth and so on.
Where the future of law and lawyering is in this area,
And
right?
that California is actually taking steps to
Get
look
people
at.
who are good thinkers and good teachers off that group, that could just a really interesting.
Yeah, so you're thinking just maybe 3 panelists, all from that access committee, but the 3 different subcommittees or whatever. they
Yeah,
have.
sort of different, or with different approaches, one of them a lawyer person, one of them an economist, if there's an economist, I don't know, there are different ways to do it, to break it up in a way that could be.
I think they're mostly non-lawyers on that committee.
Exactly, that's
Yeah.
they would have
And
embarrassed
by
riches
maybe a
and people
consumer
from outside.
person, I don't know, or somebody who's in, I don't even know who's on it. I know the lawyers who are on it.
Wendy? There you go. Wendy Chang is a former chairperson.
Yeah, well, so, and Mark is on it too, right?
Yes.
Mark
It's on the
Johnson.
ABS MDP committee.
So there are different people who could
Yeah.
they carry different flags, and we could pick the people who we think would be most fun.
Yep.
And see if they come.
Really?
All right, so that's one. Can we go back to the list?
Yes.
All right, so then post-conviction discovery. Is that, who put that on the list?
Randy did.
Okay. My fear is that we don't have enough of a criminal lawyer group, not only among us, but among the audience.
Yeah.
So this one's already covered in the FER.
Right.
So that leaves.
Advertising rules. Oh, kill me now.
How about marijuana? Did we talk about?
We haven't talked about it
Well,
yet. I'm just going in
that's-
order.
We decided to combine these two together.
Yeah.
I like that. I think that's
1.2.1.
fantastic.
Can I weigh
Oh,
in?
well,
Yeah.
So I did for the ethics, whatever update that we did, the advertising one. And I talked for 20 minutes about advertising and solicitation, at which point I was myself quite bored. So, I would, if we're choosing between advertising rules and
And anything else?
cannabis,
And so, no.
I think, particularly in California, I see it at my firm too, the cannabis practices, that business, that industry is taking off. I think that as between advertising and that subject, we could get some very interesting speakers,
Yeah.
lawyers, folks in the regulatory side from, say, the city and county of San Francisco.
Yeah.
Reputable people,
Sessions,
perhaps
it's
from the
busy.
business side of it, who might have an interest in on the ethics of this. I think that would be a more fun, enticing from a bring people in type of panel than lawyer advertising. So that's my 2 cents.
I agree with that.
Me too.
Yeah.
And frankly, more cutting.
Here,
Yeah. What's that?
Topic, frankly, more cutting edge, it's
Yeah.
more topic du jour than advertising.
Yeah.
It seems like everyone likes the marijuana
Exactly.
immigration.
I mean,
So that would
I
that
prefer to make it a hit.
Are we gonna vote?
We're
or
gonna
we're gonna
vote
make a
unless we only get 4 that we like.
Okay.
Probably.
But that's certainly, I think advertising is off.
Well, this was Richard Solomon's suggestion.
I didn't propose that I don't think it stands alone as a presentation. I thought it would go into updates.
Yeah, updates would be good for that.
It's an interesting new opinion.
I'd be making mad money for a bar if we did that.
It'd be under that. Yeah, there you go.
I mean, there is some interesting law around, new interesting law coming up around conflicts, but I'm not sure it's worth a whole panel.
Yeah, I mean, if there
We have
were,
4 now.
you know.
I would add the Shepherd Mullen opinion too on that.
Well, Shepherd, sure, you could do a whole panel on Shepherd Mullen.
Sure.
Pretty
That's
interesting, actually.
At least there.
VR recommendations.
Oh, really?
But you know, it's kind of, it does blow up a lot of stuff.
Shepherd Mullen.
Yes, indeed.
So we'll just go back to this.
That's a good one. Of the fee arbitration options, that one I like.
How many do we need? 4?
Or total.
Well,
So
3.
look at 3 here
One.
before you get to the fee.
So I think we already
do
have
have
the
it.
3, right?
Yeah.
Update.
feel like we have.
Oh, add-ons, okay. There you go.
Those are pretty
So
good.
take out post-conviction. Yeah, they're really good. This is the quickest one I've ever, discussion like this I've ever been at.
And then the FER one, what's the title of the FER one?
The FER one, there's a bunch of different ones that they
The one-
suggested.
I think the how to draft an enforceable engagement fee agreement.
Yeah. A little basic. I mean, there are some interesting issues out of Shepherd Mullen, like, how good is your arbitration clause?
It could just be one aspect of a different, bigger
Yeah,
panel.
yeah. Well, I guess we should look at all of them.
Yeah.
Let the PR people take it.
Yeah. Is anyone in here do fee arbitration? You do?
No,
I mean,
not
I've
so much
done it.
anymore, but I used to do quite a bit.
Just curious.
I'm on the Santa Barbara
I've
panel.
litigated
I've
it,
done
but I don't.
a number of them.
Okay, all right, so. See, the problem with these, I feel like, is they're all pretty basic, so it's true.
What would be non-basic?
Right.
Well, what if we did an examination of, I just don't know if, the new rule 1.15 and Shepherd Mullen would tie together well. But I view those as being somewhat fee arb related, as well as being elevated and sophisticated, particularly with whomever's going to moderate it from this group can.
Well, Shepherd Mullen is interesting, because it does, the arbitration piece, the advanced waiver piece,
Do they-
and
so
the
is
fee
there an hour and
forfeiture
15
piece
minutes?
are all interesting, right?
Is there an hour and 15 minutes?
In that case alone.
Exactly.
No.
So
But
could
you
you
could-
pair that with the new rule? Well, for some aspect, I'm not sure.
Program and alternative fee structures, including flat fees in the new rule. You know, I mean, the MFAA stuff, a lot of it is pretty basic, but that is, I think, a little bit cutting edge with the new rule. Alternative fee structures, value billing, flat fees.
You could put the Heller case in there.
The new Heller case?
You mean the unfinished
case?
work doctrine?
When didn't we talk about that last year or no?
We certainly talked about it at the last update.
Updates, yeah.
Yeah. It would be a different way of talking
Yeah, I
about
see
it.
what you're saying, yeah, okay.
I don't, I'm sorry, I'm gonna just ask a dumb person for this whole discussion. So what are the mean, I understand, what would we be saying about alternative fee structures? What are, like, here they are? Like, rule 1.1.15 that says it's gotta go in your trust account, the client's trust account, unless you get the client's consent, right?
If somebody would really come out and talk about all the ways people are structuring fees, you know, all the different ways that plaintiffs and defendants structure fees and actually talk about it, right? And throw some agreements up there that we could look
Before you
at,
go,
that would be hugely interesting.
Is his opinion gonna be on the next agenda so he knows?
No.
Okay. So
It
you're
won't.
off the
We'll
hook for the
take-
next meeting.
We'll take 2 months, we'll talk about yours in, not next, the one after.
Okay.
So you have 2 months.
Bye.
Bye.
I think that's very interesting, Steve, what you said.
Right.
I think that's very interesting what you said,
Yeah.
that idea about looking at different fee agreements and like different issues that could be included. I mean, I'm trying to think of just obviously linchpinning into ethics issues too, right? Or is that?
I mean, I my problem is I don't know, I just don't have enough background. It was like the beginning when I started to get into ancillary business, and I kept saying to everybody, what are people actually doing?
Yeah.
And I don't know what people are actually doing in the. David, do you have some ideas?
Well, I mean, people are looking for alternatives to hourly fees.
Yeah.
And there's discussion, I think you could discuss hybrid fee arrangements. You could talk about the, you know, sort of a refresher on the basics of traditional fee billing, and then get into alternative fees, value billing, hybrid fee structures, some of them quite complicated. Negative contingent fees.
Yeah, that's the kind of stuff I'd love to hear about.
Third-party
you know,
payers.
Success fees.
Yeah,
Success
client-
fees. Are they unconscionable? You know, what are the issues with success fees? Benchmark billing, you know, in terms of billing, you know, at different stages of the matter. I'm working on a fee opinion now for San Diego that talks about, you know, it used to be flat fees were, some people, in fact, MFAA had a fee arbitration provision saying flat fees earned on receipt. We know now from 115 they're not earned on receipt. And that if you don't earn it, you've got to get some of it back, but how do you calculate it? And a plug for the importance of timekeeping, which I continually try to advocate, even in flat fee or contingent fee scenarios. I think there could be a lot in terms of alternative fee structures that could be talked about beyond the basic stuff.
Is that enough of is that
Who would
moving
we
away?
get to do it? Who would be the really interesting people? I mean,
From
you
the
sound like one of
FAA.
them, but who else? We're gonna get people who would really.
I don't know every member of their committee well. I know Ken Bacon by reputation more than anything else. He's very knowledgeable.
Carol Buckner's on that committee.
Carol Buckner
Or
used to
she
be
was
there,
on,
yeah.
or she was on that committee.
Carol Buckner
Oh,
would be
she'd be
great.
great. Yeah.
But to be the moderator or to be one of the panelists?
To be, well, maybe a panelist, maybe, I would assume a current committee member probably is moderator.
That's what I would think, okay.
Maybe somebody currently like Ken from the committee while it's still around, before it sunsets.
I'm not saying we're inflexible, I think the idea was for a co-prac member to be the moderator, maybe one or two MFA people as a speaker and then somebody else, it's up to you.
That sounds good.
But, I'm just saying.
Sure.
Well, I don't know, the MFAA would really, you know, we probably would need to find somebody with a little more grounding in novel fee structures.
Right,
'cause
That's what I'm thinking.
I mean, we need someone
MFAA
at
is not really,
At a interesting firm that does some plaintiff's work and some, I mean, we could try would it be more plaintiff's firms or would it be more defense firms?
Somebody from the
Could
Rosen
be either.
Bean
Well, I
firm
think
would be
like there's
interesting.
mass torts,
Oh, it's our.
plaintiffs firms that deal with those mass torts where they have multiple clients and they're trying to figure out, they have to do some creative fee agreements in those situations.
yeah, sometimes a little too creative. Yeah,
Who knows someone who could do it?
I'm sure you could go to the MFA committee and have them recommend somebody. You guys don't have to try to think of it, I'm sure they can think of some people who could check off a lot of these boxes for you.
Really? I mean, I just don't know why would they particularly know those people?
Oh, I don't know.
Because they just deal with, I mean, I'm just imagining that these complex fee arrangements are more sort of high, like larger kind of matters that don't tend to end up in mandatory fee arbitration. So I'm thinking of this group, is there anyone who has contacts with someone who's at, like a lawyer who has a practice that might often involve novel fee arrangements? I mean, I can ask at my firm, there may be someone.
I could ask Carol, because she's now, with a big firm in San Diego, that Carol may have some insight into someone to talk about sort of not, Carol Buckner.
Yeah.
Non-traditional
Are
fee
we,
structures.
are we up here or down?
We're down there.
Down
We're in
there.
LA.
Okay, that's good.
In LA,
Because
yeah,
we want
that's
it,
convenient
we
for her.
prefer to get, we don't like to pay people's travel, or we don't pay people's travel.
Let's not get her. She'd be a good person.
But there's
All
some
right.
people not here today that might know someone, so.
Of course.
Is that enough of an emphasis on the mandatory fee arb to like satisfy that they're being represented here, or is that too sort of?
I think we have to, they're gonna have to get used to being part of what we do, right?
No, I just meant on this one topic. I mean, we were like, yeah, we're gonna have one that is like an
But
MFA sort of topic, right?
They're used to doing, it seems to me that they're used to doing programs that are directed at generalist lawyers.
Solos.
And, here are the basics, and here's how you, the 10 chips, right? And we're more directed at law lawyering types, so we got, that's where the emphasis is. Law of lawyering.
Yeah, but I mean.
How many generalists do we get at these events?
After Aguilar now, large, their fee arbitration action is going to be before JAMS or American Arbitration Association or someone from one of those providers might be a good person to talk about more complex fee arbitrations.
That would be interesting.
But at the same time, I don't want to slight the MFAA people because they do play I think, an important part.
No, I'm just saying, and all I'm saying is that for presentations at our symposium,
right,
it doesn't make sense really to do the top tips, 10 tips, right?
Well, that's kind of basic.
That's what I'm saying.
That's boot camp stuff.
That's all I'm trying to say.
Yeah.
That's all I'm
Right,
trying to say.
and all of the topics that they proposed are of that ilk, because that is what they do, and it's understandable, but they don't fit with the typical topics that we do at this symposium. But I'm sure they themselves have things to contribute to a more complex
Yeah, I
topic.
mean, I'd like to find a place for them in the program. I don't know if it's possible because he's on the board of trustees, but Sean Saleg would probably have some insight into more complex fee arbitrations. I mean, I don't know if he can participate because he's a trustee, but
I don't think it would be a problem.
just as someone maybe to ask her as a resource.
Yeah, well, he's my partner, so I'm happy to ask him.
Oh, well then, there you go. Perfect.
But, okay, well, I mean, maybe this one could be a bit mushy because we want to collaborate with the MFA people anyway.
Right.
So we could kind of leave it as that
That's fine, I guess my question is, what are the next steps we're talking about?
for them, with getting to them.
I'm sorry, honing in on this topic, you mentioned reaching out to Carol Buckner, Sean Saleg. How are we gonna refine it after this meeting?
Who are the,
We'll need a
who are the third year folks who are going to moderate? I just can't even.
Matt,
who's not here.
Richard.
Matt.
I'm the only third year here.
Congratulations,
Yeah.
you get
With
to
the
pick.
numbers right now.
And who was the other,
Eric, right? Or is he?
Oh,
Is he
Eric.
third? Yeah.
Yeah, he's a sort of third year plus.
Yeah, Eric, Matt, Richard, Dina, Steve Sparta.
All right. Okay, well, I think that whoever's gonna do it is gonna, I mean, typically the person who's gonna be the moderator kind of gives more shape to it, right?
Absolutely.
So maybe once we get maybe we can leave it kind of loose, and then once someone gets assigned to it, it's on them to sort of help to refine it.
Sure, and we can share the suggestions of reach out to Carol or Sean.
So do we have?
Dina, you want to do the panel?
Yeah, I'll do the, not that panel.
Oh.
I'll do the UPL one that we were talking about, or that, if we pick that, if we ultimately select that.
So let's figure out if we have 4 now that we are like.
So I'll move
Or do we have
these.
more than 4 that we need to vote? We need to vote.
We just move these
We
down
have
here.
just 4.
So yes, we have 4 now. Ethics update, advising clients when state and federal law conflicts, marijuana, immigration, UPL, MJP, MDP, and ABS.
This is super. It's all very cutting edge.
Very interesting. And fee agreements, alternative fee structures.
Great.
Good.
It'd be called like the future face of law.
Yeah.
All right, so we have 4, so we've done our job, and now I guess we could circulate the 4 topics to the people who are gonna
Correct.
be the, and you.
Well, 3 topics,
Oh,
because
3,
usually
that's right.
leadership takes on the first, although there's nothing to say that 2 third years couldn't be on the same panel, maybe. But if they bring a specialty. So we'll just send an email to those third-year people and let them send us their preferences,
Got
and
it.
we'll assign it based on their preferences, I guess.
Yep.
That sounds good.
That sounds good. But there's only gonna be 3 that would be moderated, and then the 4th would be the update, which is.
Leadership.
Leadership, right. Okay.
Or you could add a third year if you wanted to.
Yeah, I mean, that's the thing is, the shame of it is, there's 4 third years, and if all 4 of them want to moderate a panel, I think we should make that opportunity available somehow.
Okay.
So, I don't know how, but somehow. Chances are Drew will still be in trial and he'll have to get some. Okay, great.
What's the date of the symposium again?
April 8th, I think. Hold on, I have
That's
it.
the following week, it's the week after that.
It is, well, that's the other, not April
It's
8th.
like 18th or 19th, right? Which-
April 18th or 19th, and then the question becomes, should the meeting or the symposium be on a Friday? So,
With the other day being a Thursday.
yeah, Thursday or Friday, which day should be a symposium? Last year, the meeting was on Thursday, symposium was on Friday.
Last year we had the meeting on Saturday, but we can't do that anymore.
You can't do that, oh, is it on Saturday?
Yeah,
Yep,
Okay.
it was Friday and then Saturday.
That's the question.
I mean, I don't think you were there, Mimi, but we were there on Saturday.
Yeah, that's right.
Oh.
Because Andrew was
Yeah.
you, and it was pretty funny. He did a great job, absolutely.
So it's the 17th and 18th?
Yeah.
Or, I'm sorry, 18th and 19th.
So historically, what works better to have, in terms of bringing people in and getting attendance, to have it on a Thursday or a Friday?
So we've always had it on a Saturday generally.
I'm sorry, I mean the symposium.
Yeah, for many years, symposium was always on a Saturday. The last 2 years, we've done it on a Friday. And it was fine.
Then we had the meeting on Saturday, right?
We did last year. Now,
We can't do that now,
correct.
so the only way we can do this is to do Thursday and Friday.
Correct. So I guess one day is right, to choose which day we want the symposium.
Can we do the symposium on Saturday? Or is that a no-no?
That's right. We can't host events on the
Got it.
weekend. Committees can't do
Cross-dimension.
events.
So my vote would be, and I don't know the answer, so to prioritize the symposium on the day that we think more people will show up, and then whichever is the other day is when we would have our meeting. I don't know whether we, what day we would get more people. I'm thinking, my gut is thinking Friday, because then professionals get their stuff done, and then they can hold open Friday once they've gotten all their stuff done, whereas if it's on Thursday, people might say, oh, shoot, I still got obligations, I'm gonna skip the symposium.
Just so you know that Easter falls on that following Sunday, I don't know how vacation, you know how kids have winter break or Easter break or whatever break, young kids. I don't know if parents take that off to take vacation.
I think a lot of breaks are actually like before that, because April's so late this year that a lot of, if you're talking about like the school system, like a lot of spring breaks are in end of March and beginning of April, but it is, I mean, not being is Good Friday, what day is Good Friday?
That
That
Friday.
day.
That,
Friday.
we probably shouldn't do it that day then.
Good Friday's the 19th.
But then we would have our meeting on Good Friday then? That's
Good Friday is the
That's the
9th.
alternative.
19th.
19. What was that week?
So we have bad Thursday, then Good Friday.
I just think attendance is gonna be low on Friday.
Huh.
Yeah.
Lululemon have a strong Catholic.
It's not just Catholics. Christian.
Okay.
Good Friday's not good.
So is Jew, I don't know.
Well, Good Friday wouldn't be good, no. But it's on the 18th, Thursday.
And there's always the option that people can't come, they could always do it via webcast.
They can webcast
Yeah, that's true.
from the pews.
Yeah, doing it on Thursday will definitely aim us for attendance.
And we're stuck, right? There's no moving this a week before or anything like that,
Well, we have to.
or after.
Well, I can't wait to
After,
have kids.
because it's Jazz Fest, I don't know.
Yeah, it's,
That's like,
I think 11th, 12th.
some of us worship at a different temple, so to speak.
That's right, that's Passover week.
No, because Jenny has all the Fridays in April, except for that one.
Right.
The Jenny,
A meeting fine.
Well,
and all the Saturdays too.
yeah, the following, what's the
Jenny
following?
gets to be
how'd we get
outside,
stuck with Good
you know.
Friday?
What's that?
Jenny's really.
What about the week of the 26th?
I don't even think they realize new in Easter. I mean, Easter is so weird because it's different all the time, you know.
I can't wait
I
till
mean,
your
it
kid
was at
is
the
in
end of
school.
March last year, wasn't it?
Just when your kid gets into school. I just want you. Since we're
Mm-hmm.
So
The thing I got going for me is that most of the schools and colleges, so she gets the days off.
And she has generally the same timing.
But, yeah,
Does she work
the
at
school
Redwood?
system that she's at, she used to, right now she's at, she's in that school district, she's mostly TAM, I think.
CSF commission.
Yeah, but we could take EF&G for the, I mean, if we kept the symposium on this date and our meeting on this date, and then we talk to MFA and see if MFA could, there's not that many.
It's tough for us to
Say right now.
say right now, yeah. Is maintaining the April dates are, is that highly discouraged?
What is what, how did it work?
Maintaining the April dates,
Well-
18th and 19th.
The fact that Friday is Good Friday does seem to be a significant problem. And I think our attendance would suffer if it was on a Thursday, would be my instinct.
And maybe some speakers wouldn't be able to do it because of that day too.
So, yeah, I think that, if May were available.
Okay, you know, we can look into it. Is everybody in this room comfortable with May 2nd and 3rd? Do you have access to your calendars?
No, I'm not.
You're not comfortable with that?
No, that's a planned vacation.
Okay.
I'm speaking at an ABA conference in New York.
On the 2nd and 3rd? Yeah.
All right, well, maybe we go back to Thursday.
But not that you need me. I don't
No.
have a role, so, you know.
Right.
Well, we need to at least have a quorum, and I don't wanna.
Yeah.
I can assume some people who aren't here will be able to make it, I don't know about everybody.
Thursday, the 25th, you mean?
No,
No.
no, we're talking about May.
What
2nd.
about the week of
okay.
May 6th?
But how
like
is
the
it
9th and
possible
10th?
that the
our next meeting would be on May 2nd or 3rd, that can't be right.
No, we were looking for an opening
Oh, we're not.
to move the April dates.
We're not just
What if we
looking for the
moved it
co-practic.
to the last week of March? Is that too early?
I know that that's spring break for like San Francisco Unified OUSD. Whether that affects attorneys being on vacation with their family, I mean, we could find reasons not to do a bunch of dates, but I'm just saying that as
What
a
about the
concept.
second week in May, the 9th and 10th?
That would be.
No, we don't.
Right, so.
We don't have one in March.
Right, there's no meeting in May, so that would be, I think, easier to move it to May, because we don't currently, won't,
Then we don't fly people.
right, we won't be
pay to
meeting
fly
back to
people.
back, and, yeah,
Not fly, so people who wanted to come will be paying for themselves.
right.
Who come from that.
Right.
The sun south.
But I mean, if we moved the April meeting to May,
Right.
so they're coming out for the meeting and the symposium in May instead of April.
The thing is, since we're kind of rotating which opinions are being talked about, following meeting is a month after that. We're 2 days shy of a month after that, but it's fine. Whoever had their assignments for the May meeting wouldn't be doing it for the June meeting or something.
Right. I am totally lost as to what we're proposing now, and
May 10th.
I'm really concerned about the fact that we're now at about a third of the committee to make a decision like that.
I agree.
So I think we're just gonna have to have this one. Is this something that we can do over email?
So what we'll do is
As long as staff
this.
is doing it?
Why don't, if that looks like the consensus here is the other option is May 9th and 10th, we'll send out an email to the entire committee saying, look, this is the day that we have it scheduled. We're considering an alternative date. Please reply and let us know if this date works for you.
Yeah.
Or we'll do a doodle poll or something like that.
Yeah. Okay.
Would that be all right?
Yeah.
Yes.
So the
Yes.
alternative would be the 9th and 10th, but if
Okay.
it seems like the majority can't do it that day, then we'll just keep it on the day it is.
Okay.
Yeah,
Yeah, okay.
we may have to, be bad on Good Friday and have the symposium.
I'm not concerned about like our mortal souls, I'm just concerned about our attendance.
Yeah.
Okay.
We'll do it.
All right. Now we're gonna shift to what are we talking about next? Let me see the schedule. So we still have yet to talk about marijuana and the attorney rating and website. We can get both of those done. And I don't, let's talk about the rating website one. And let's just take a 2-minute move around break. And then come back and do that. Did everyone get a copy of the, this? Great.
For the billing, he wants the billing.
Yeah, yeah, obviously not like you, whatever from like Steve's.
Yuck. It's gotten all nasty and rainy out
I
there.
know, and then I'm like, seems like there's 4 people here, right?
I know, it's like every second,
Like,
every time I look
can we like
up,
vote
I'm
on
like,
anything?
someone else is
Somebody
gone.
I didn't even notice Adam leaving, all of a sudden I'm like, is Adam gone? Like,
Yeah,
That's crazy.
I know,
like the first January, it's like.
I know, it's
last
the
year,
worst
same thing,
week,
and it's
isn't it?
like everyone's trying to rush to get their opinion, come back from vacation, get their opinion,
yeah,
and it's
it's
like
really
scattershot
tough, but
and.
it's so
yeah.
close to the.
And it gets really busy because no one's, seems like people don't do anything, and then
Yeah.
all of a sudden clients are like, oh, we want this, right?
Right.
So it's like,
Yeah, that's a tough one.
Yeah.
And did you say that Drew's in trial?
He's like coming up on a trial, which is why he seems to be like he wasn't here last.
I don't think I've
this
seen
month.
him the last couple.
Yeah,
Yeah.
he's like, ever since like
October, he's been completely slammed. Like, he's
Oh my
had me do like at least 2 speaking things for him.
Oh.
Yeah, I don't know what the heck kind of trial it is, but it seems to be, they're a pretty small operation, his firm, so when they get a.
Oh, I think they have only a few people that do what they do.
Right,
Yeah.
right, yeah.
That focus on that, so that's interesting. Well,
Oh, good, you haven't left.
Still here. I wouldn't want us to have to break,
I
right?
know, at a certain point, it'll just be me talking to myself. Amy, give me comments.
Reminds me of like soccer. You start 11 versus 11. Then once there's no longer more than 7 on a side, the game's over.
I'd forgotten that rule. That was one of the ones I used to know and I refereed.
You referee? I referee.
Uh-huh.
Good times.
I like refereeing.
That's fun. You know, you run around, get outside, have to make decisions.
Do you referee for adults or kids?
I used to do professional games.
Really?
But that was pre-family.
Yeah, yeah. Do you have kids who are old enough to play?
I have an 11-month-old.
No.
So he can kind of sort of kick a softball, but that's about it.
Yeah. I never reffed anything more demanding than under 17 girls traveling teams.
Oh, that was demanding.
That is, with the parents on the sideline, that's very demanding.
Yeah.
Oh, yeah, well, the tougher games were actually Oakland with some of the Hispanic teams. That was very intense.
When I lived in,
The parents were super intense.
I went to UCLA from LA, so I used to go play high school games in college to schools that had metal detectors, which, you know, I grew up without that. It was very jarring to see how some of the, you know, kids have to go through in order to have an education.
That's very
But it was, you know, I felt that the sports were a way, it was a great outlet.
Absolutely.
For a lot of those kids.
Absolutely. Anyway, where are you based now?
We live in Maine.
Well, you'll have lots of opportunities for refereeing.
I remember, so,
You'll probably end up coaching, you know?
yeah, I will. My first game when I moved up to the Bay Area, I was at Berkeley, I did college camp too. And I got off the BART, and I'm this brand new guy from Southern California. I get off BART, and there's a parade going on. I'm like, oh, this is so nice, Berkeley, there's a parade. And then I look closer, and there's dads with their kids on their shoulders watching this nudist parade. I'm like, wait a minute, where am I? What is this? We don't have this in Northridge, California.
My daughter used to call the Beta Breakers the naked dudes race.
Yes.
Naked dudes race.
So different up there.
Yeah.
It's really.
Yeah. Well, that is you'll have fun. You'll have a lot of fun with that. I'll tell you, parents who coach who can set a good tone
That's exactly it.
are more precious than gold.
Yes. Contain that innate desire to yell and scream
Right,
at the
exactly.
referee.
And create. I mean, my daughter was a good soccer player, but her favorite coach was her first coach on just a house team.
Right.
Right. Yeah. And girls used to warm up. They would count their warm ups in 8 different languages.
Wow.
It was.
oh my God.
It was really fun. They were really had a good time. All right.
Okay. Let's get back to it. I know.
Thank you.
Just asked me to do it.
Everybody's got their umbrellas.
Yeah.
Is it raining?
Yep.
Dang it.
Yeah. Didn't bring your umbrella?
No, I always have my umbrella. I don't trust San Francisco. At least during the winter, I don't trust San Francisco.
Faux leather can't hang in the rain.
Oh, it can. It's just My hair. I just took the time to straighten it today.
All right. Let's talk about, do we have a quorum still?
It doesn't matter as long as I'm.
You had a quorum at the beginning?
Yeah.
It actually does.
But we can't vote on anything for publication
Oh.
if we don't have a
Well,
quorum.
that's a problem.
But do we have a quorum?
Yeah, that's a problem.
4, 5, 6, 7.
We have a problem.
Yeah, we can't vote out anything, but
If you didn't ask, you couldn't tell me that. But if someone questions whether there's a quorum has to be taken.
Really, Brian?
Yeah, after this issue came up. Because I went to the default, once you have a quorum, you always have a quorum,
No.
right? Robert's rule says no.
it's not always a quorum. You can
It's,
still meet, you just can't vote on anything.
Yeah, but, all right, I mean, I know there's a bunch of points about that 12.003 in case.
Well, I thought we were gonna discuss 12
Uh,
like Amy's revision.
Yeah, I'm going to probably about.
All right, that sucks. We'll do 12.003 next one.
So, just so I'm clear, Amy, your edits are made on top of Drew's, you
They are.
accepted all of Drew's?
Yes, I didn't want to take them out because I wanted everyone to see them, but my edits are on top of this.
Okay, because
Then what I should have done, what we should have done was take your version and compared it to the previous meeting version. So that you could see Andrew's edits and your edits in red line.
Well,
because I will say, in yours, I don't see some of Drew's edits in red line.
interesting, well, that,
Unless, so
They
like line
should
77,
be.
78?
Oh, I don't know, I just copied hers.
yeah. All right, well, let's just, since we're not going to talk about it today.
Anyway, it's not a big deal, but for the next meeting, I want to use yours.
Yeah.
That's why I'm asking.
Yes.
What I'll do is I'll go through them.
Just make sure we get both theirs.
And then I'll send that to you, so you can work off it if you need to do any further.
I don't think I will, because
Okay.
it's not going to be.
Good to know, I'll see reconcile.
All right.
Drew
What?
Are we moving to the marijuana one? I
We
was
are.
like, yeah,
We're
okay.
talking
So I was
about
like, I
marijuana.
don't have that printed out.
Okay. So, Steve, I think this is you and Kendra, I'm not sure. I think it's you and Kendra, right? Your work product?
Yes.
It is.
The marijuana opinion? No. Yes. 17,001. So who wants to kick it off? Steve, you sent out a bunch of questions for us to think about.
did. All right, I'll kick it off.
Great.
So there are two pieces in the way we drafted this. One is, how is it that you can counsel or assist a known federal felony? And the second is sort of what are all the weird things that also play in terms of things like your fees being forfeited, your current client privilege, and a whole host of other things that Kendra has written up really beautifully. So I'll talk about the first half a little bit. There's obviously a lot of, the infrastructure isn't there yet, we haven't set out everything we'd want to say about state or federal law. We haven't outlined the authorities on preemption and conflict. So for our purposes today, discussion purposes today, I think you should assume we'll do that in a reasonably competent way, hopefully by the next time we discuss this. But what I did try to do was to set out the basic rationale for why counseling and assisting is okay in this area, or exactly how it's okay. And I took as the template for that, my theory was 1.21 is where you ought to go. And you ought to see how much you can do out of 1.21, and then basically argue that everything else, because it's vague, is controlled by 1.21. That's, in a way, what the LA and San Francisco opinions did. They didn't have 1.21, but that was their basic approach. It makes sense, I think, to do that. And beyond that, on that piece, I don't have much more to say, except I'm interested in whether people think it's persuasive. I know it can be improved and rewritten, probably reorganized. I already have some thoughts about that. But the real question is whether the argument itself makes sense. And a little bit, I'm interested in the question of how much policy discussion should we be doing? And one piece of that is sort of how much of this depends on the fact that marijuana really is sui generis in some way, as opposed to some more general analysis. We've talked a lot about, we've talked a lot about ways in which this kind of rule could be perversified in ways that none of us would be willing to get behind. So what is it that suggests we're going to be behind marijuana but not behind whatever the new governor of Alabama might want to do on race relations, for example? That's just an hypothetical. So I'm going to stop, except to say that with respect to the disclosure piece, the question that I found myself focusing on is how much of this is stuff that we want to tell lawyers they have to talk about, right? Either because of 1.4 or because of 1.7, and how much of it is stuff that we would want to say, well, there's a lot of stuff you ought to be thinking about as a matter of competence, but we're not going into all of that. That's just a question. I don't have a clear answer to that question. So I'll just put that out there. I don't think there's much. I don't want to take up the time otherwise.
Well, I think all I want to add to that piece is that when we discussed this before, and this is many, many meetings ago that we touched on this outline, the debate was, like what you just said, that the new rule is the same concept that San Francisco and LA used for their opinion. And so did we want to then go further and address some of the other ethical components that come into it? I was in favor of that because I think when an attorney who does this type of law is reading it, they're going to want to know or get our guidance on some of those other things. But I do believe that it is a slippery slope and that we have to be careful as to what we touch on and what we want to include, what we think we can,
And I'm totally persuaded that a number of the things you talk about have to be in there. I think it's going to be a responsible opinion.
Right, and so I did a lot of research and tried to put in everything I was finding with the thought that we would discuss it more, talk about it, maybe narrow it down a bit, and see what we felt comfortable including. But I also would be very interested to talk to some lawyers who actually practice in this area and see whether they think that list is comprehensive, if there are other things that come up, how they handle the situation of, let's say, attorney's fees, for example. I don't have a lot of experience personally with this type of law or advising lawyers who handle this type of law, so I kind of felt like I was flying blind a bit. So I don't know, in our small gathering here, if anyone has any personal knowledge of this type of law, but if not, maybe it would be helpful to have at one of our meetings, invite a couple people in who do this type of thing. Like,
If they want to be at a publicly noticed meeting of that.
Well, so the San Francisco Bar just put in a new committee, a cannabis committee. And those members, their leadership came to me and said, hey, is the California Bar going to write an opinion on this? I mean, they're waiting for something to come out. And I'm sure all of those people would have opinions on, or be able to express
Would they like to
what they're
have
dealing
lunch
with.
with you and me?
Maybe,
That
yeah,
kind
I
of-
think we
that-
could.
That strikes me as something that could be incredibly helpful.
Yeah, we could do a lunch or invite them to come to our public meeting.
Either one.
Because I think, doing the research can only take us so far. I think hearing a realistic perspective of the day-to-day, how they deal with some of these obstacles could be very helpful.
Yeah, I agree. So reactions, help us out here. We're interested.
I generally had a positive reaction to it. I mean, I think it's, it's sort of, I'm not sure what more can be done. Even though it, it's tricky. I was interested in how you thought about whether marijuana is sui generis. Now, I mean, it would be nice if we could make that argument, because we don't like, you know, if you do try to put it in other frameworks, it gets uncomfortable. But I mean, there are some arguments. There is something to that. Sure, I have a ton else to offer. I mean, I guess, did you do the exercise of kind of turn around and think about, you know, what if we're talking about like a law, you know, segregate schools?
I'll ask one of my partners is really into this stuff, so maybe she'll I did. I mean, I think it would have to be doing some of that. It's got something to do with sort of sense of, well, we're trying to, we're doing something different that's bringing order to chaos. That's
right.
That's creative, that there's some kind of movement in favor of, and that somehow federal enforcement policy, though it isn't in any way decisive, seems to be about creating some space in some way, or has left some space for this. And it would be, you know, because I think if federal enforcement policy didn't leave that space, you wouldn't have anything to talk about.
Right.
So it's some mix of that kind of stuff.
And you're not trying to like discriminate or marginalize or like, you know, impinge upon the rights of a particular group, like if you're talking about a broader application of it, you know?
I think that's also maybe a good point. We're also not, you know, I talked a little bit about with my son, who is definitely progressive in his views, and he said, this is about the rights of oppressed people. Which I don't quite think, but I do think that somewhere on the continuum, it's not about squelching oppressed people, for sure, in lots of ways, and that may be part of it too.
Yeah, I think people are very hungry for the guidance, and I think obviously they're looking to our state to provide it because it's such a hot topic here. I mean, unlike some of our other opinions, this one I think is one that we really, as the state of California, have to push because people are waiting for it. But I do think that we need to be very careful with what we include and or what we find important enough to advise about, because there is so much gray area.
But yeah, do you have to worry about, in terms of the ethical analysis under 1.2.1, do we have to worry about this question we don't want to tackle of what would be the result if the roles were reversed, or what
I think
happened?
we deal with it only indirectly by saying why, you know, writing something that indicates that we don't think necessarily that these things could be reversed, or will make it hard to reverse.
Do we have to, I'm just curious why we have to talk about the reverse nature of things.
I don't think we do, but
Okay.
I think we just want to
Think it through though.
we want to think it through, and I think we want to justify what we're talking about in terms that don't lend themselves to easy reversal.
Because the rule permits, from an ethical perspective, the providing advice of complying with state law, notwithstanding the fact that it conflicts with federal law, and your exposure under federal law would still remain. But the discipline by the state bar would not be applicable, even if the roles were reversed. So, how do I say it? I'm just not sure, although it's interesting and might be a difficult question to grapple with, I'm not sure we need to be distracted by that in this opinion. So said another way, if you violate a federal law and it's criminal, notwithstanding the fact that someone's conduct is ethically permissible under the rules of professional conduct in a particular state, you very well may still have criminal exposure even as the lawyer. This isn't gonna
Yeah, and then you
absolve
get in a
them.
position where you're the witness as the attorney, and you then are grappling with your ethical obligations under the California rules of confidentiality versus the federal rules that say
Right,
there's
notice
no
that, notice that under
confidentiality because
California
it's a
law, you
it's a
would
crime.
be,
Or you have the trust account rules in California, and you have banks under federal law that aren't willing to.
But in the
take
criminal
money.
context, there's, as you know, the amendment to the evidence code, which permits you not to disclose privileged communications with respect to advising on marijuana.
in state court.
Correct, right,
Right, but these prosecutions are gonna be federal court.
correct.
Right, so I think
you may have that
it's the
disclosure.
balancing of what you need, what you are allowed and required to do under California law, which will be all great and fine unless there's an issue, a criminal issue under federal law, and then you're gonna have to kind of weigh those obligations.
I have a broader question about that. Do you think that how do you not do some kind of potential conflict disclosure here? I mean, isn't there, or maybe there should always be a potential conflict disclosure here?
Yeah,
That's at least that's the way I've sort of felt about it. As I read your list of all the things that could go wrong, I thought to myself, boy, there are a lot of ways.
right, I think that's
that-
what it is essentially. It's a conflict disclosure, and these are the points that you're making under it, yeah, for sure.
I love that the statement of facts was short and concise, notwithstanding the result of the rest of the outline being very long and difficult,
It's a work in progress.
difficult issues.
Sorry, I had to step out during the part of that discussion about whether or not we're talking in the opinion about
We don't have to.
flip case. No, I don't think so
I don't
either,
think we do.
but I think we have to think
We'll
have it in our
write it,
heads.
well, I'll write a better version of the uniqueness argument, and then people can see whether they think it helps or hurts the opinion. It's perfectly fine, I think, to stop with the text of the rule, and a sort of elaboration on what the rule is about in terms of the way it balances the policies. You could just stop there. And that gives you plenty of juice to get through the vague provisions.
Right.
And you don't have to, you can live to fight another day on the question of how you want to distinguish marijuana from segregation.
Yeah, I mean, I don't think you know, it's, if you don't do the distinguishing, you do leave yourself a little bit open to the idea that maybe in some point in our history, the federal government wants to tolerate state laboratories in racial discrimination, and our opinion says, lawyers, go ahead and advise your clients.
Go for it, advise
Yeah.
your clients.
I mean, I guess in a way, maybe, I mean, it's uncomfortable, but in another way, I mean, we do think it's an intolerable situation to have lawyers not able to advise clients on something that's legal in their state. You know, I mean, even if it were something distasteful to us.
It's something about it. It's legal, it's complex.
Right.
it's got criminal penalties attached under state law, right? I mean, there's a lot of different pieces to it. And I do think that somehow it has something to do with this notion that it is a kind of, it's a quasi-legitimate experiment. I don't know how to describe it, something like that.
Yeah.
Well, recall, I mean, I don't think this is the point you're making, but the rule took great care to not limit itself to marijuana.
Of course not.
Yeah, it's anything.
It's very clear,
Yeah.
but because among other things, they wanted to capture immigration.
And so, I only raise that, I mean, I understand that it's interesting, I just don't want you to be distracted from struggling with this difficult issue of other states might doing things which are, we all feel, or some of us may feel, is more nefarious than advising on marijuana. I mean, that's, for me, that's not, the analysis is the analysis, notwithstanding the fact that, yes, we might feel differently about it in a different context, but I don't, my sense is.
Well, we'll have a chance to look and see if we want to say anything.
The analysis would be the
We
same.
may not want to say anything more. That's all. We may want to just do it and not worry about that.
And to be frank, you know, the chief trial counsel, if the lawyer is engaging in overt criminal conduct that violates, that's a federal crime, you know, 6106, what we talked about earlier. I mean, there's still other avenues for a lawyer to be disciplined, notwithstanding they quote unquote advised on marijuana business, notwithstanding the fact that this rule is in existence.
Oh, we're going to say in the opinion, at least, we're going to say 6106 isn't there because 1.21 takes away moral turpitude. How can you be engaged in something that's, how can it be a moral turpitude offense if 1.21 permits it?
So 6106 might not be the best, may not have been the proper vehicle for me to say.
Well, it does raise a question. I mean, I think there's a difficult and interesting question which we haven't talked about, which is, what if you get convicted? It's one thing to say, okay, we won't discipline you, right? Now you've got a conviction out of the Northern District of California, judgment of conviction, so forth and so on. And somebody, you have to report that to the state bar yourself. Right?
Yes.
Right? And then I think there's an interesting question. My mind sort of brain froze at exactly that point, but I did have a thought that was something like, isn't there something about anti-commandeering doctrine? Right? You know, the whole idea that federal agencies, state agencies don't have to enforce federal law or be federal law enforcement people. So maybe the state bar can say, yeah, you convicted them, we don't have to disbar them.
Right.
That's correct.
We don't have to disbar them because that's doing your dirty work. And we won't be commandeered. I have no clue. And my instinct is to sort of have a footnote that says we're not opining on what would happen.
That's not how the system works.
How does it work?
If you're convicted of a crime, any crime, it's a misdemeanor or a felony, the bar is going to get involved.
In what way?
Well, pursuant to the criminal conviction statute 6101, 6102.
And what happens?
What happens is by law, the conviction is required to be reported to the state bar.
I got that.
Yeah.
The record of conviction is required to be filed. And then there's going to be a hearing as to whether
Is there always a hearing, or do they look at what the charges are and see if there's, moral turpitude or other?
Well, if they look and see if it's either moral turpitude or other misconduct warning discipline, which is a huge, expansive, the limits of that are not clear.
Right.
But so what are the implications of that, David, for this scenario in which a lawyer gets convicted for conduct that 1.2.1 comment 6 says go for it, and then federal
The lawyer's culpable, there's two ways to analyze it. Is it other misconduct warning discipline? And to the extent it violates 6068A, the lawyer's duty to uphold the law. I mean, that's another alternative. The theory is that lawyers convicting crime undermine public confidence in the legal profession. So even,
even if it's a crime that supposedly is countenanced under the rule, I think there's still going to be some kind of analysis in state court as to whether this is other misconduct warning discipline.
Well, I guess that brings me to the question of how much do you find compelling Steve's argument that that it would not be, to advise a marijuana business would not be failing to support the laws of the United States.
Well, you're talking about somebody's been convicted of a crime.
Right, because it is, some of the stuff you would do could be a federal crime.
60688 says it is a lawyer's duty to uphold the law of the state of California and the United States.
I understand that, so what do you think of
so when
the way
there's a
Steve
conflict between.
analyzed why that wouldn't be a violation of that?
A violation of what?
Of the statute that you just cited to me.
So it
Let's
wouldn't
just
be a
find
violation? No, it
let's-
would be a violation.
Well, that's what we're talking about.
Yeah.
But I mean, can we opine that it's not, is the question? Because,
Well-
which is what San Francisco and LA have both done,
Right.
right? Or they've already opined, and with a less strong disciplinary rule. And
Well, this is why I think the San Francisco and LA opinions
Yeah.
are very vanilla, because they don't get into any of that. They just scrape the surface, which I think was a good first step, but it didn't really help anyone.
I'm not sure we should resolve this issue the way I hear it being framed, that you would be disciplined or you would not be
No.
disciplined. I think it'd be
No,
very fact specific.
I don't want us to do that,
We
but I
haven't
think
said
this is a
that.
really
We
good
said
way
that
of
we're not,
engaging.
we've already said this isn't binding on a disciplinary prosecutor.
But what I feel like this is allowing us as a committee to engage more with the ideas here. Like I'm saying to David, look, what Steve has written here is that because of 1.2.1 and how specific it is, I don't, this damn thing didn't come out with page numbers, so I can't.
That's my fault.
Well, it's not, it doesn't matter. I just think it's interesting because I feel like we've.
What's subpart?
It's four subpart 4B subpart small Roman 2.
Okay.
Given the way 1.2.1 provides a specific approach to balancing state and federal interests, advising the client of their legal rights, and assisting them in implementing the device as legal under California law.
I think this is right.
Is not failing to support the law of the United States.
So
So I guess I'm asking if you think you disagree with that.
Do I disagree with it? It doesn't really matter. And will a state park court judge disagree with it?
Well, here's the opportunity, because I
And
think.
I suspect that they will.
Okay, but I think the committee needs to decide whether we analytically think that's correct.
Yeah, we can, and to the extent that might give some course law in state park court a good argument for why it's not other misconduct warning discipline, I'm all in favor of it.
Well, for
That's all we're
example,
trying to do.
for
I
example,
think we're also trying to be true to what the Supreme Court did, right? The Supreme Court pulled 1.21 out there. Now, they're a little cagey in the way they draft 1.2.1, but
Right.
it goes a pretty long way towards allowing criminal conduct.
I mean, that would
Right.
certainly be my argument on behalf of somebody that.
I get the state bar.
Of course, law.
I think that there's a really good argument the California Supreme Court didn't want people to be disbarred for this.
we have a second.
Well, there's only one way to find out, and that would be
To disbar them and see what happens.
So, but I think the
discipline
key
them
point-
and
I think the
petition
key
the
point-
Supreme Court.
I think we have an opportunity here, though. I know
Yeah.
we don't like to address, a disciplinary scenario, but we do.
Yeah.
But David was absolutely right in terms of procedurally how it would go down. And so you have somebody in court who's done this.
Right.
You have somebody in the state park court who's done that. It's analyzed, is it moral turpitude? And we could say, no, it's not.
No, not moral.
And second of all, the question is it something warranting discipline? And we could say no. And
Well-
somebody going into court would have that, would have that to work with. That would be helpful.
I agree,
Because
but
other
the
misconduct
key,
warning discipline conceptually, it's not moral turpitude, but it's other conduct that reflects on the lawyer's fitness.
Right, right.
And Teresa
Which is
saying, we could
permitted.
say, no, it's not other conduct.
Yeah.
but we should
Because
be
of
careful,
1.2.1.
right, and use the language from comment 6, so long as the advice given was compliant and lawful under the laws of California at the time it was given, and your conduct otherwise I have to be careful how I word it. Maybe we'll just stick with that part. Because I want to say, because I think it is important to say, lawyers could, although they're advising on this issue, could find themselves in a disciplinable setting. I think there's going to be a lot of prosecutorial discretion.
Absolutely.
And that's
Right, and that, I just opened that door in that little section that says limitations.
We don't have to go too far.
But I think the reality is that we're gonna be pretty clear that this is not a get out of jail free card.
Correct.
Right?
Right.
It's not, but I think we can
It's more like
address
a
Ken-
talking point.
Yeah, if you're,
We could drill down and get the advisory value out of this one that Kendra's looking for.
yeah, if you're laundering money on behalf of your client, who's
Exactly.
otherwise operating a marijuana business in California, I mean, there's all kinds of hypotheticals you could come up with that, in my view, would still expose the lawyer to discipline, notwithstanding. that
Well,
there's-
by the way, I think that laundering money is already covered under our analysis. You wouldn't be protected because that would be a concealment offense.
Totally.
So you'd already be subject, even under our analysis, you'd be subject to discipline.
So,
I mean, I don't know,
It is
I
interesting.
unfortunately, for some reason, I can't find the opinion on my computer, but I don't know if we want to go to a place where we analyze the other misconduct warning discipline case law. I mean, there's quite a bit of it. It talks about the parameters of the doctrine and the basis for it. But, you know, I don't know if that's appropriate.
That's a great question. I think I should, if you have some,
oh yeah,
if you can quote me the great, send me an email with a couple of the greatest hits there.
I will.
I'd like to look and see if that makes sense.
You'd like to play some tracks?
Yeah, exactly. I want a special channel for legal ethicists, the sort of Spotify of legal ethicists, right?
There's a lot of crazy Supreme Court case law, including I think one decision with 4 separate opinions that sort of talks about it. And yeah, there's a lot of potential, but it's all very vague. That's the problem.
Right. Well, that's good. I like vague. I mean, in this context, I think vague we can deal with, right? It's I'm worried about something specific that's going to undermine us and make us look like fools.
One thing that I think is very interesting is, obviously there's law firms in California that are doing this. And I think a lot of them have looked at these ethics rules and have tried to have ways that they can be within compliance and not fall victim to the federal issues.
Right.
So that's why I want to talk to them, because it'll be interesting to see whether their kind of go-arounds are ethical also. And to see if there are any pitfalls that we need to point out there.
That seems more like a lunch discussion than a public committee discussion.
Well, but you're right,
Hearing
Steve.
how you handle these issues. We're not going to put that on our pen.
But you're right, Steve. These people who are practicing in this area of law, they have in their engagement agreement all these disclosures and all the conflicts that are going to come up. They already have that all developed. So. I think it would be interesting to get that perspective from.
Exactly. I think there's a lot of judgment and risk management that's already been devoted to this in a much more fine-grained way.
Right.
Yeah.
I have an unfair question for Andrew at 4 o'clock on a Friday. Can you think of any? I'm just thinking for analogy purposes, because we're talking about this tension between 6068 and the rules of professional conduct. 121. Can you think of any ethics opinions? You don't have to answer this now, and maybe someone else has an answer, where the opinion has discussed a seeming tension between a rule of professional conduct and the Business and Professions Code, and had a discussion about whether or not a lawyer might be subject to discipline, or at least navigating this issue where the lawyer's conduct might comply with the rule, but not necessarily comply with the Business and Professions Code, or vice versa.
Yeah, there's it's not criminal exposure, but the duty to withdraw while being ordered by the judge to disclose the reasons why you're asking to
Yeah.
legal representation of client's case.
Yeah, I'm just
Now-
thinking, are there some analogies we can draw to other situations where that tension's come up? I don't know if it will work
Conclusion reached in
perfectly.
that example might not be as palatable as the audience.
Well,
But you know what, I
there's
think we
gotta
have to consider that, you know, if there is a potential downside.
Well, there's gotta be some example where, because California's confidentiality provision is so much stricter than elsewhere, there has to be some examples where attorneys have been asked to reveal confidential information on a federal level,
Yeah.
where they've had to choose between, you know, the
Certainly
strict.
there's Sarbanes-Oxley. Well, there's all the stuff about Sarbanes-Oxley. What did we, I can't remember, some states actually sort of went through this and kind of said, well, you know, if, Sarbanes-Oxley has some, what? It has some withdrawal stuff and some disclosure stuff that's not consistent with California law.
Right.
We have, this committee did a ethics alert on Sarbanes-Oxley. In spring of 2004. New SEC attorney conduct versus duty of confidentiality. And I think it's been a while since I read it, but it's essentially abide by the duty of confidentiality until otherwise determined not to.
Yeah.
Well, it's that
Doing
Wadler,
much
that
because-
Bio-Rad case that.
Yeah, because Part 202 rules, 205 rules, and the legal and ethical responsibility of Californians are quite complex and only generally summarized in this article. Members should not rely on this article as a complete explanation of their potential conflicting rights and duties.
That's correct.
What happened in Bio-Rad?
How do you get to this, Mimi, that you just pulled up here?
That was that, like,
It was
the
okay,
former
right?
GC, yeah, I'm sure,
Yeah,
that,
can you send me
I
the
think
link?
they waived, there was a bunch of privileges waived because of the disclosures to, like, they made those disclosures, but then they tried to pull it all back and say, but you can't use that against us in this context. Well, I'm trying to remember, but I know that's like the intersection between
That is.
that Sarbanes, and then California ethics rules and a bunch of different stuff, but.
I think he wasn't liable.
Because it may be safer for California attorneys not to accept the SEC's invitation to disclose client confidences to the SEC, at least until such time as the preemption and good faith issues have been decided by a court of competent jurisdiction.
Right. Well, I don't,
Send that to Steve as well, Mimi.
Okay.
I think you're totally going in the right direction, Steve. I mean, I think this is as well as we can navigate it, and it's as complexly thought out. It's, you know, we know in this case that we're trying to get to a certain place.
Yeah.
I mean, we have to.
I think the only question I think is, I just flag this as a point of anxiety that I would feel as a counseling lawyer if I were giving advice here. We say, and I think that's pretty persuasive to me, we say, look, but there is this language about when can you assist? And it says, well, you can basically assist in, what is it, interpretation and compliance,
Right,
right?
just horrible phrasing.
Yeah, well, but it's deliberate. I mean, as I recall, when we were
Yeah.
going through this,
Yes.
we tried to get something broader than that,
Yep.
and the California Supreme Court rejected it.
Yep.
Nonetheless, in this opinion, we cheerfully say it is broader than that. Well, one thing, I guess we say, actually that covers everything, right?
Because it has to, otherwise.
Because
it
it
wouldn't
has
make
to,
sense.
because it wouldn't make it, because it's just not workable otherwise, and, which I think is actually right, but nonetheless, there's no, the fact that they rejected the broader language is a troubling point for someone giving advice.
So should we flag that?
No.
No. No, I don't think so. I don't think we should.
We
But
can't speculate
I'm
as to why they
I'm
reject
mentioning
that.
it. I'm mentioning it because it
Calculated
bugs me.
ambiguity.
What?
Calculated ambiguity.
Yeah. Well, it's just, yeah, exactly. That's what it is. I mean, they just didn't want to go there. The Supreme Court did not want to get past, they said, okay, yeah, you can assist all you want, provided you're just explaining the scope of the law or doing what's necessary to interpret the law. But, yeah, but that's just not how it's going to work. Can't possibly work that way. So, but that's all they were willing to put on the record at this point about their willingness to countenance assistance in the violation of the federal law.
Right.
So we're doing their work. We're carrying their water for them. I think. But I think no other alternative. I just couldn't figure out. It felt like crazy.
Right. So, Kendra, I was wondering what you meant when you were talking about your section and you said it was a slippery slope. What slope?
Well, first of all, I'm not sure that this is a comprehensive list. I think these are the main issues that I saw over and over again in my research that came up. And then I think one of the gray areas is what we just talked about. I mean, if you get in a situation, you're advising your client that should the federal government pursue you and should then I get in trouble for this and become a witness in your case or whatever it may be, all of these issues come up. But I obviously didn't get into what does the lawyer do following California law versus federal law in that circumstance. So here we're just saying you're going to disclose this, you know, mention the conflict and what could result, but it stops there. And then I guess the other thing that I wasn't sure how to separate it is I first have the list of disclosures that you're going to give to the client, and then I kind of highlight a couple things that the attorney themselves need to worry about, although I think the list and the disclosures could also be things that the attorney needs to worry about. So I don't, right. So I don't know how we want to split that up or not split it up and just, I don't know.
Well, I wondered about that. I mean, it seems to me some things, there's sort of some things that really go to the attorney-client relationship. And those are things that I sort of, and those could trigger if we're just saying, like there are things there, we haven't yet really talked about the requirement that you disclose limitations on your conduct, your, you know, sort of limitations on what you can do. But that would seem to that might seem to be something we could organize some of this material around.
Yeah.
Clearly, another thing we could organize it around is the whole, we could organize it around, also organize it around the concept of what you have to say about scope.
Right.
And then the other one, it seems to me, is the potential conflict is a really, and the sort of confidentiality, privilege related ideas.
So here's something that I thought of and did not put in here, but it's just an example of if we were to go a little further with this. So attorney's fees, for example, and the issue of, let's say, accepting a $10,000 deposit from this marijuana business that you're advising ethically under California law, but then you go try to put that $10,000 deposit in a federal bank, money laundering, but you have to do it because of the trust account issues and blah, blah. So how are these law firms and lawyers that are actually doing this getting around this issue? And I know that some of them are accepting Bitcoin and other alternative currency, which gets us into another ethical issues and you know, things that we have not since provided guidance on before. So I think when I say slippery slope, I mean if we open some of these doors, you know, what?
Bitcoin helps because it's not cash, right?
Well, I think there's a big debate out there as to whether is it property or is it, you know, actual money that you would then have to comply under all of our rules for trust accounts and stuff like that. So there are some doors that we have to make a conscious decision on this committee whether we want to open and go down that road. Now,
the more doors we open, the more helpful this will be for people that actually practice in this area, but it could end up getting away from us. a bit,
Yeah, and I
so.
think the further we get away from the California rules of professional conduct,
Yeah, but I mean, like the Bitcoin thing, that plays into those rules, or just alternative currencies in general. So, I mean, that could be a whole
A
opinion.
whole
Yeah, I was gonna say
No.
that's a whole opinion.
I was
Right.
gonna say, that sounds like a fantastic
Yeah.
opinion.
Yeah.
Right, so we are starting to write one in San Francisco on it.
We are in LA too.
Oh, good. Yeah, that can be a whole opinion, but I think this type of practice lends itself to some of those alternative strategies, which again, open up doors for other ethical issues. So that's just one thing we have to,
Maybe we're gonna have to slam some of those doors.
Yeah, I do.
Because I
Yeah.
think we wanna get, my instinct is, in an ideal world, we do 2 more drafts of this.
Yeah.
And get it out the door.
That'd be great.
Yeah, I totally agree. I think this falls under the category of get it out there and get some comments.
yeah, but I do think if you think, Steve, a lunch would be a good idea, just to,
Yes, I'd love to.
I'll try to set something up.
Okay, I'm in the city every, Tuesdays and Wednesdays in
Okay.
the city. And I'd be thrilled to meet with folks there.
Okay, and like I said, they just set up that new section for the San Francisco bar, so I'll try and find out when their meetings are. Maybe it's something where you and I can attend one of their meetings.
Yeah, maybe
and-
that would be fun too.
I'll try and figure out a way to
Yeah,
facilitate
that would be totally fun from my perspective. That would be great, and we learn a lot.
Tuesdays and Wednesdays.
Yeah, but I'll come, if they have evening meetings, I'll just come into the city for that.
Okay.
Okay, I'm gonna cut you loose to,
All right.
I think, I tend to think, Ken, on your thing, like you're at about the right level of, a little more, but like I think flagging issues is the right way rather than resolving everything.
And we can cut some of what I figured I'd put more in than maybe we needed, but.
All right, is there anything else we can accomplish? I do not think so. Oh, let's talk about what we're gonna do next month. So when is our next meeting?
Feb.
21st or 28th?
February 21st?
The 21st in LA.
February 21st. Okay, that's a good long way away.
22nd.
We get to get a sense of the group that you and I and should be.
Oh, no, we'll do that next.
Okay.
Let me do this. So we are gonna definitely talk about marijuana next, at
Right.
the February meeting.
Right.
We will, yeah, so far, what's on our list?
So far, you have agreed to
Dina's,
Dina's and ancillary business
okay.
and
now marijuana.
And 12003.
And 12
We will definitely do 12-3. That hopefully won't take long.
Marshall.
Yeah, okay, I'm gonna put a lot on, we might not get to all of it. We'll do 17-003. We're gonna put, 13-002, and we're also gonna put, I'm sorry, that's wrong, not 13-002. 14, colleague impairment, 14-001, and also 14-002. We'll have all. Oh, and when does the comment period end for the discovery period?
It actually, yeah, ends unfortunately shortly after.
Well, no, that's actually good, because I have too much on our agenda anyway.
Okay.
So we'll talk about the comments after that period is closed, which will be the meeting after that.
One more time, 12-003,
Yes,
13-003,
correct.
14-001,
Yep.
14-002,
Yep.
16-002, 17-001.
Wait, not
No.
16.
Oh, sorry, not 16-002,
Right.
17-001, and
Yes.
17-003.
And 16-003. See, where you said 16-002 at the end.
Yeah, okay, then you got it. Yeah,
1, 2, 3, 4, 5, 6, 7.
all right, so we'll have to be kind of bustly. All right, last thing, we want to ask the sense of the group as it is now. Are you interested in making any kind of
written comment to the Board of Trustees about the proposed size. I mean, I think Steve and I are.
Just
Sorry, the
individually
proposed-
or
The
from our
no,
committee?
from our committee.
Yeah, for sure.
So the
Oh.
proposal to shrink the committee down to 7. And also when I, let me, what's that?
I oppose shrinking it to 7.
I think it should be bigger than 7, maybe smaller than what it is now,
Correct,
but
yeah.
7 seems too small.
Especially given that we're also taking on the MFA
Exactly.
project now.
Yeah, it's not a long project, but the premise of this, I was a little hot under the collar after I heard the news. So I went out. The premise is that our committees are wildly bigger than those in other states.
Well, we are widely bigger than almost
Yeah,
every
but-
No,
other thing.
but wait till you hear.
Yeah.
So I went to look and see how we do against the other states with large numbers of lawyers.
Yeah.
We have the smallest committee of the states with the 5 largest number of lawyers. We have we have the smallest committee compared to New York, which has slightly more lawyers than us. We have about half as many members as New York. So the basic premise as applied to us just seems off, really off.
Yeah, I don't think many people will be signing up to join if we make it so unbearable with the workload and, I mean, we're already all busy as it is with our numbers now and all the opinions that we have on the table, so adding in the extra tasks just compound that issue, yeah.
No, it feels that we ought, on behalf of the bar's own interests, we ought to push back a little bit.
Yeah, and then especially I would be interested to know like how they're envisioning the composition between like the non-lawyer and then the community members and members of the public, because if hypothetically, if they were saying 7 and then it's like there's only 4 lawyers on it, we all know that's not gonna work, right, in terms of a lot of these issues it wouldn't be. So I don't know what the thought is on that, whether they're gonna get rid of that requirement, whether they want to, what part of that composition is.
And there are issues about if it's 7, it's way too much of an insider thing, and then there's also this sort of issues of how do you get representativeness geographically in terms of different segments of the profession. All that stuff doesn't seem to fit very well with 7. Plus the classes of lawyers, then you'd have 3-year session, it'd be 2, 2, and 1.
Yeah.
And you'd
a
have
very persuasive letter.
Well,
It's gonna be
what
good.
are you proposing? I mean, what is the consensus that we're gonna propose? We should keep the
We
current
don't know. We'll see
configuration?
what you guys think.
What do we
Okay.
have, 14, 15 now?
We have 15, I think?
16, 15, 16, including the advisor. So let me just say, having observed many committees and commissions go through very similar concerns that are being raised, the size as compared to other jurisdictions is totally unpersuasive.
Why is that, Andrew?
Because the board is not persuaded by it.
But their consultant gave it to them as a reason for cutting.
So I'm just giving you.
What about the workload argument?
So why was it?
Right, let me just tick through them.
A
So-
one-way ratchet.
So, I'm just saying, other groups have made similar concerns. We're the biggest bar. Our composition is smaller than these other large states. I'm just telling you.
Doesn't work.
Okay.
It doesn't work.
So what does?
However,
Yeah.
workload, representational diversity amongst the committee, I think is a persuasive argument. It's good to have a public lawyer, a criminal defense lawyer, a trust and estates lawyer. I mean, now, you don't want 4 malpractice defense attorneys, not casting any aspersions, but that's typically the lawyer that applies generally. But if the job is to be a standing committee to advise the board on any given time on an issue to be assigned to us from the board, breadth of experience would help benefit the board. And then just touching upon the workload and the ability to get out ethics opinions effectively and efficiently is going to be made difficult, and to articulate the reasons why 4 persons would be difficult. For ethicists, as I think Dean's got the math right, if we were dropped to 7, you'd have 2 MFA, 1 public, 4 ethicists. That's,
We better hope that the MFA people know some ethics, because otherwise it's a total crazy scheme.
so anyway, that's just,
And what would the quality of the product be? It certainly wouldn't be as good as.
Well, and we already have opinions that have been around for years. Imagine what that backlog would be like.
right, well, I think,
That cuts both
the
ways.
agenda is gonna drop.
Well,
The size of the agenda would get much smaller. So anyway, your
Does
Free
it
to
make
provide
sense,
comment?
Andrew, to say that this is actually about to be a golden era, because now that we have this new set of rules, there are all issues and so forth and so on?
Yeah.
I like that.
That's a great one.
There needs to be a lot more interpretation of those new rules, right?
both educating lawyers, it helps keep lawyers out of the disciplinary system by getting out in front and educating them on what their obligations are. Ethics opinions do that, COE opportunities do that. And yes, there's been a seat, as the board well knows, there's been a seat change as of November 1st, 2018, with 70 new rules.
I bet we could get former chairs. I bet we could get a bunch of former chairs to.
Oh, absolutely.
Has the Office of Professional.
Endorse this, whatever we
The-
decide.
The other point, don't be argumentative, defensive, or combative. Be helpful and persuasive. And I say that, anyway.
Yeah, that's a good point. Is the Office of Professional Competence taking a position on like vis-a-vis this committee, what the recommended number is, or would you, or no? Not yet, okay.
I absolutely would if I'm asked.
Okay,
Okay.
thank you.
Did I sound like you? I'm sorry.
That's okay.
If you don't mind, something. Oh, you mentioned he was, oh, well, 12/002, I'll overcome.
Fine.
And,